14. Okay, all sides are duly represented. On the prayer made by Mr. K. Mazumdar on counsel for the petitioner, is permitted to withdraw this petition and to approach the competent authority. Matter stands dismissed on withdrawal with liberty as prayed for. Listing due to the courtmaster. (45) and 48. Okay. (45). (48), are you there? Okay. Oh, okay. For 45, on the prayer made by counsel for the petitioner, matter stands adjourned today. In 48, interim order extended till next day to restrain. Both sides represented, huh? Okay. Item 7. Okay, just a minute. If you are going to continue the interim, let me see that. Item 7. You see, this is why I called it up. On 6/12, this matter was fixed for consideration of motion as well as interim order. So there can't be an automatic extension of interim order. There's a judicial order of the court to consider prayer for interim order. So you have to make some submission. But yes, what is the policy? Why this, what do you call, exclusion of this petitioner? Why it has happened? You have got instructions. Okay, let the matter be called because this is when issue is in. Be present. You're not adjourning it right now. (22). 22 password for the day is paid for by non-counsel for the petitioner. Please say all sides are represented. Okay.
Daily list item 1.
Then we'll issue a notice and then we'll stay. No, because of the reason if the instructions are produced, we may dispose it of right now. This matter will not take some time. His case is that he had scored higher and then somebody else got the appointment. Yeah, no. Your case is that they've been shown higher marks than what they have allotted. Correct. No, that is okay. But you see, let us take an example. Guwahati University, somebody gave an exam of under Guwahati University, some test or exam somebody gave. He got 20 marks, and in the mark sheet you are showing him 50 marks. This is an absurd example, but still it's only an example. No. You see, marks are not allotted by these candidates. For that, will take a different course of action. Because the government can't take two stand. Number one, in APSC cases, you will say that no, there was a scam. And here, when the petitioner says that you got, candidates got lesser mark, and you gave them higher, shown as higher, it's a greater scam than APSC. And that is why records are not coming. No. Don't protect these officers. Do not protect these officers. Because you see, it will amount to government taking two stand. It'll be because then it will take a political color. You know why I'm saying so? Reasons are obvious. Because if the government is protecting some, and the government is for the same offense, government is prosecuting some, there can't be any other answer. Because if they have done the manipulation, it's worse crime than theft or murder. In murder, somebody is killed instantaneously; he is dead. But when you deprive somebody of appointment, they're extremely say will say that if the records are not produced, the officers will be personally present and show cause. No, you give a date, but we'll make some observations so that these officers, if not okay. $17, okay. List on both sides are represented. Sorry, the learned counsel for the petitioner and the school education department are represented. Mr. SMTCC, learned counsel for the school education department. School education department prays for some more time to obtain the records. Next para. The reasons why the records were called for is contained in order dated 21/9/2023. So the matter was posted on 11/10/2023 for production of records, and on the prayer made by the standing counsel for the school education department, matter was adjourned for today. Full stop. Next para. While granting time to the learned standing counsel for the school education department to produce records, the respondent authorities in the elementary education department are put to notice that on their failure to produce the relevant records, why the court should not take an appropriate action against the concerned respondents and to recommend a CBI inquiry in the matter. A CBI or a vigilance inquiry in the matter. Full stop. The non-production of records on the next date will be viewed very seriously. Next para, list on. When do you want? Just give a date, we'll give that day. Okay. 21/11/2023. No, not 21, we're making it 22. 2023. Okay. Next para. Before that, you say that the learned standing counsel for the school education department shall transmit an order of the court to the respondent authorities in the elementary education department.
Item 2.
Compassionate appointment. Not there. Just give a scroll G Assam for item 2.
Yes. Yes.
We'll wait for some time. Item 3. Yes, what is your instruction? No, then we'll issue a direction, let the government constitute a 1 or 2 man committee. Because if people are getting not getting certificates, we'll issue the. No, I understand, but you see, I am a student. I got my LLB degree, and the Bar Council is not functioning. Correct. So we'll. We'll put it in the order. It will be easier for you. Heard Mr. A.C. Buragohead and the senior counsel, assisted by Mr. R. Singh, counsel for the petitioners, and also heard Mr. B. Gogoi, learned standing counsel for the health department. Next para. The learned standing counsel for the health department appearing for the pharmacy council, and the who's also appearing for pharmacy council, has submitted that as per his instructions, the pharmacy council is not functioning and there are litigations with regard to the constitution of the council. Next para. Considering the said submission, the privacy appears to the court that as students of the candidates are clearing the B.Pharm examination, they are required to, or any other higher degree in pharmacy, they are required to statutorily register themselves in the Assam Pharmacy Council so as to commence their profession. To stop non-functioning of the council will not be in the greater public interest. And therefore, the court query to the learned standing counsel for the health department is whether, in view of non-functioning of the Assam Pharmacy Council, it could be the government can consider appointing a government-sponsored committee to no, this council itself is not functioning. So then the government will take over. Okay, with approval, if required from the Pharmacy Council of India. To secure, to ensure that public interest is not suffered. Next para, the learned standing counsel for the health department is granted a week's time to obtain instructions in this regard. Okay, don't say 1 week's time. You're granted time till next week to obtain instructions. The next list on 24, 11/2023. 27th, okay. 27th is a holiday. Then we'll go to 29th.
Item 4.
Yes. Any instructions? Pardon me? Then we'll issue a notice and extend the order of stay. For Mr. K.B. Pathak, counsel for the petitioner. For school education, you are there. You are appearing for school education. School education department. Is standing counsel for the school education department, representing respondent numbers 1, 2, 3, 4, 5, and 6. You are for 7, Mr. Dekar. Mr. Dekar, and counsel for respondent number 7. 1 to 6 and 7. 1 to 6 is Mr. Dekar, and 7 is Mr. Dekar. If you notice a motion returnable in 4 weeks, requisite extra copies of the writ petition is served on the Honor State and Departmental Council in course of the day. First of all, interim order passed on 22/9/2023 stands extended till further orders.
Item 5.
You've got instructions. What university? We'll wait for Mr. Fukan. Oh, Mr. Fukan is there. It's okay. Mr. Fukan. Something has to be done. The projection which is made, I think you'll have to carve out an exception. The court was right in issuing that direction. No, may not be, but exceptional case. Okay. Suggest a date. Next Friday, 17th. Oh, okay. All sides are duly represented. Mr. P.J. Fukan, standing counsel for the Guwahati University, submits that as there is no rule in the Guwahati University Act or statutes or ordinance framed thereunder, the university authorities are seeking some more time to provide him instructions. So accordingly, matters stands adjourned today based on 17/11/2023.
Item 6.
Please speak loudly. I'm not hearing you. Oh, acha. Yes, yes. You got instructions? No. Oh, government advocate is not there. Just make this scroll like that. Senior government advocate shall take notice that no government advocate is representing is present in court number 7. Huh? No government advocate is present in court number 7. We'll see for 10 minutes. If they don't appear, then we allow all the writ petitions in motion stage. It's okay, because you see, we can't wait. We'll allow the writ petitions if there's no government advocate. We can't help it. Ask them if they don't come in 10 minutes, then we'll start allowing all the writ petitions in motion stage.
Item
No, it's
7.
okay. If they don't come, you can't do anything. Then we allow the petitions on that ground alone. Then the government will have a right to appeal.
Yes.
Is they will lose. Okay. We'll wait for 10 minutes, otherwise we start passing orders.
7.
Yes. Just a moment. You have got any instructions? Then we'll issue a notice and extend the interim order. No, now we'll pass an interim order. Miss A. Hussain, counsel for the petitioner, and Mr. A.R. Tahibullah, learned standing counsel for the Higher Education Department, representing respondent numbers 1, 2, 3, 4, and 6. 3, 4, 5. Okay. This court, by order dated 6/10/2023, directed the respondent authorities to provide reasons as to why the candidature of the petitioner in the said post was not given consideration. Despite order dated 21/2/2023, consider it is the respondent authorities were also put to notice that the candidature of the petitioner was not accepted because of communication dated 1/2/2022 by the Undersecretary to the Government of Assam in the Higher Education Department, and that by order dated 21/2/2023, this court in WPC 1268 of 2022 had interfered with the said order. However, instructions as called for has not been received. Next para. Accordingly, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Honorable State and Departmental Council in course of the day. Next para. Pending any till further orders, the respondent authorities are jointly and severally restrained from finalizing the selection process for the post of Assistant Professor of Bengali within bracket unreserved bracket close in R.G. Barua College, Guwahati. Oh, actually, there is one more thing. Just missed it out. The petitioner shall also take steps in course of the day for service of notice on respondent numbers 6, 7, and 8 by registered post with AD. In addition, the petitioner shall also serve notice on the said respondents by way of Dasti by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Take steps today. But then we'll see. It is also provided that in the event the process has been finalized, the appointment so made shall be subject to further orders that may be passed in the writ petition. Correct, you are right.
Item 8.
Yes. You have to give Shoko's that prayer for amendment did not wash out. The making allegations is very easy. No, no, it's not a question of your being sorry. But there an affidavit has to be filed. Where is that? 13. Oh, acha, it's there. Okay, then we allow him to amend the petition. Okay, this I did not notice. But Mr. I. Hazarika, counsel for the huh? I say, I'm sorry. I said something else. Okay, I'm sorry. Okay, I'm sorry. It's a sign of growing old. Uh, uh, Mr. I. Sekia, counsel for the petitioner, as well as Mr. S.M.T. Chistik on the standing counsel for the secondary education department, appearing for respondent numbers 1, 2, and 3. Next para. Pursuant to the learned counsel for the petitioner has submitted that pursuant to order dated 12/10/2023, the petitioner has filed show cause reply on affidavit, and it is submitted that the offending words were inadvertently typed out in paragraph 7 of the writ petition, for which he prays for forgiveness and prays for not drawing up any contempt proceedings. Full stop. It is also submitted that, in addition, the petitioner has also filed the connected IAC 3179 of 2023 to allow him to amend paragraph 7 of the writ petition. Full stop. Considering that that in paragraph 3 of the show cause reply on affidavit, filed by the petitioner, whereby he has tendered unconditional apologies, the disparaging remarks, the court condones the mistaken part of the petitioner to use disparaging remarks against the honorable judge in paragraph 7 of the writ petition. Next paragraph. As we can see, you have no objection to the amendment application. Okay, as the learned planning council for the school education department does not seriously object to the connected to the prayer made in the connected IA Civil 3179 of 2023, the prayer for amendment as made in the said interrogatory application also stands allowed. Most of the petitioner shall submit a amended writ petition. And thereafter the matter will be listed in the motion column again. Pardon me. I didn't hear you. No, whenever you do, it will come. I have not said list after so and so days. Whenever you file it, it will come.
Item 9.
Yes. Oh, yes.
So their name is not reflected, everyone names are not reflected notice and the disciplinary commission of extra color. They have a secondary department as a department is not a party. But all I is told as a secondary and GH.
Just now. Okay. For that, I think Mrs. Varman will appear.
Yeah, okay, on your paper one.
Okay, if she appears for one, she'll also appear for two. You give extra copies to. No, I don't know, but it's not there. If she has received copy, I don't know because she will. Because you see, if even if you have served copies, it will be in the office. She will not have it now. Correct. You give it, we'll take it up at 2 o'clock. No, that's why he will inform Mr. Sutia. Who is he? I don't know.
I think.
D Chakravarti. B Chakravarti. Okay. Please inform them. We'll take it up at 2 o'clock. At 2.
Item 10.
Yes. Some matter which was adjourned. Yes. Please speak louder. I'm not getting your voice. Yes. Oh, okay. Yes.
And then continuing students one one of the subsequent events and
No, you see, Supreme Court, a particular bench of the Supreme Court has referred the matter to be taken up before a larger bench. Correct. So when they take up is not within our scope of debate. And in this case, the issue which was referred, I think from 19, today we are 23, 4 years or 5 years have gone by. Correct. Now, in the meantime, a 3-judge bench has given a judgment. That is NC Santosh. The NC Santosh has taken a particular view. Now, division bench of the Supreme Court takes up the matter. I've told you, I won't repeat it. And which one? I am not aware of that. But then you read that the second division bench, 3-judge bench, would be a mere Dasji. Again, here this NC Santosh was not considered. So it will not be binding. In this 2020, NC Santosh was not considered. No, what is the citation of NC Santosh? That is passed when? No. No, not 7 What is the date of the judgment? NC Santosh, what is the date of judgment? 4/3/2020. And this was decided on September 29, 2020. Subsequent judgment, not considering the earlier judgment, is not have binding precedent.
Thereafter on 18/11/2021, followed the judgment in passing the.
No, you see, you go to the book of Honorable Justice G.P. Singh, the interpretation of statutes, as well as there you will get the principle of stare decisis. Stare decisis has thereafter been explained in very beautifully in that Pranay. You have seen that Pranay judgment. So you look at the Pranay judgment. The subsequent bench judgment, which you are now placing, will be per incuriam. Hmm?
Both the three bench judgment
No. But please explain to me. I'm using that particular term, stare decisis. So can a three-judge when I have two citations with me, one by a three-judge bench, one by a two-judge bench, which has considered the three-bench judgment, which will be binding on me. 142 is very clear. 142 is the order of the Supreme Court is binding on the High Court. Now, which order would be binding? A two-judge bench order would be binding, or a three-judge bench order would be binding?
I don't know. Two-judge bench consider both the three-judge bench.
No. No, but still it will not prevail. That would be, you see, there's an observation of the Supreme Court in that Pranay Sethi. You have got that judgment of Pranay Sethi. Pass it on, because it's a big judgment. In E mode, I will find difficult to find out that paragraph.
There are the reasons.
You know what? When I was a small kid, what my father used to say, he would always say that education is one thing; it may give you knowledge, but ultimately, in life, it is the experience which prevails. I'm not. There's no hidden meaning in what I'm saying. It's just a saying which is always in my mind. You see, a three-judge bench, can it be explained? There are only two judgments of the Supreme Court, where there's in one particular bench which relates to taxation. smaller bench judgment found out a typographical error in a larger bench judgment, and it was clarified that that was a typing error. And based on the typing error, there were hundreds of other judgments which were passed all over the country because it's a tax matter. So that is one where the Supreme Court went to explain why it considered that it was a typing error, because somewhere it was in the negative, and in the final order there was a affirmative statement. So therefore the court says it can't be the scheme of the taxation, and therefore it was said a larger bench clarified the judgment of a smaller bench clarified the judgment of the Supreme Court in the by a larger bench. That is one. Second, there is another judgment where the one of the honorable judges in the bench, he did not sign, and therefore the other judge, he signed and delivered the judgment, and he gave a reason why the signature of the second honorable judge would not matter in the there are only two cases of that sort. Now here I will show you something. I've tick-marked 4 paragraphs, 20, 21, 27, and 28. Let's see that. I'm sending you. Let's see that. First two cases are 20 and 21 are Constitution bench judgment. And then 27, 28, the court says that the bench of equal strength should have been guided by the previous judgment. That is, these are the words used. Therefore, you see, the explanation by a quorum of a smaller bench of a larger bench to have a different meaning than the words which are actually used. It will not be a binding precedent. That paragraph 20 and 21 show you. And then here also 27 and 28 again explains furthermore that the coordinate bench should have been guided by the first judgment. I have no option.
Then that means that means that one is the
Precedent will not prevail. That defeats the principle of stare decisis. You see, otherwise, why Constitution will bench will interpret and say that the other judgment, the previous judgment should have been followed. Why will this Constitution bench say that? You see, that's why I use that term. Why I remembered some words of my father is only because of that experience. Very recently, yesterday somebody told me a story. Yesterday, I met a person. As- okay. I can't consider that. I can't consider that. Yes, Ms. Baman, you have anything to say? Here, I'll tell you, since you were not there on the last occasion, here issue has arisen that in respect of the decision of this year of consideration, the larger bench of NC Santosh in the Supreme Court has said, three-judge bench judgment, where it is said that the policy which is in force at the time of consideration would be applicable. Now, Mr. Roy has done a wonderful research and he has come out with on the last occasion when this was pointed out, he had referred to decision of a three-judge bench in 2020 10 SCC 496, saying that after NC Santosh, the three-judge bench took a view that it should be the date of death, the policy would be applicable. Then he has also referred to two-judge bench decision of Supreme Court in AR 2022 SC 402, where NC Santosh was considered, and the Supreme Court, two-judge bench of the Supreme Court arrived at a considered view that in a case of compassionate appointment, the date of death is constant, correct? But the date of consideration is variable. In one case, you may take a call on the application after 5 days. In one case, you may take a call after 22 years. And in the meantime, policy changes. So he said that would lead to a situation where variables will be given more what you call weight. So therefore, it should be the date of death. That view is again by another three-judge bench. Before that, three-judge bench of 2020 10 SCC. So this is the background. The third background, which took a backseat when I was hearing this matter, was what he has now said. This court in 2017 said that considered the 2-year lapse and directed that it should be considered on merit. Now again, it has been rejected on the same ground. So he has approached the court. Now, what is your view in the matter? Page 43. Page 43, yes. Yes.
Yeah, the DLC held on 23 2007 and 31/10/2008 and 15/9/2017. Three times lordship this case has been placed before the lordship. Investigative committee. And the examination examined his proposal and found that he is underqualified. As per government OMD and also 2 years salary. So but his case has been considered lordship in 2007 and 8 lordship.
Just give a requisition slip and get the records of WPC 3634 of 2013. Disposed of by order dated 15/9/2017. Name of the party is Pradeep, PRODIP. PRA, okay. PRADIP, Pradeep Kumar Roy versus State of Assam. Okay. Yes, what does it say?
Paragraph 6.
Yes.
Therefore, the meeting of these was again held on from the top minor, there are all the meeting pending cases here children trying to were placed before the including the deputy one in that dollar the DSC equal to pending meeting held on the against there are meeting gives us again held on but the thing is that it was not placed as the case of the petitioner had already led by 2 years on the date of receipt of application for application of the ground after receipt of the folio of the application, the particulars and the along with other submitted to the deputy of the the DSC meeting held on 15/11/2013, but the DSC rejected his case on the ground that the petition 3 years order was already this after all the things matter. We had 15/11/2013 that was considered in the murder when extracted case.
I've seen that order. Okay. I'm getting the records of the earlier petition. I'll pass the orders in the chambers. You get it in the evening if it is possible. Otherwise, on the reopening day, 2 days will be a holiday.
Case number will be WBC 3634 ಇದು ಕೊಡ್ತಾರೆ. Case number ಅಂತ ಕೊಡ್ಸಿರೋದು ಏನಾದರೂ ಇದು I think 10 ಸೊಲ್ಯೂಷನ್. 5634.
5634 is the earlier petition. I made a mistake. I said 63 something. 5634. Okay, 5634. Okay. I passed order because here I'll have to deal with 2 3-judge bench judgments and 2 what you call division bench judgment of the Supreme Court. It will take me some some time to dictate the order.
Right, right.
Since I have a long list today, I'm not, I'm saving some time in the courtroom.
Time being item two.
Timing item 2. Yes, you got the records. What is the serial number in that list? Shabir Ahmed. Okay. Second page. Who is the selected candidate? Page
Page 27.
27.
All the trades were examined by the government as per guidelines of the honorable court and government body and recommended the following candidates.
But this is a valid ground. Your date of submission was very late, after 3 years. Well, you applied on 3/7/2010. No, it's not there. It's after 3 years. Page 16. File your affidavit and get that record. We shall notice then. Because she's showing it is 2007. Your document says it is 2010.
The rejection letter, rejection letter is 17.
That's okay. No, that's okay. But you see, if there's a discrepancy, if there's a wrong decision otherwise, we'll have to examine it. Pursuant to order dated 9/10/2023, Ms. D.D. Burman, an additional senior government advocate, has produced the records relating to consideration of compassionate appointment by the DLC Karimganj. And it is submitted that as per the available record, the father of the petitioner died on had died on 12/3/2007, and application for appointment on compassionate ground was made on 3/7/2010. And accordingly, the candidature of the petitioner was rejected on the ground of late submission of application. Full stop. Next paragraph. Mrs. S.B. Chaudhary, learned counsel for the petitioner, has referred to the copy of application for appointment on compassionate ground annexed to this writ petition as annexure E collectively, and it is submitted that the application was submitted by the petitioner before the headmaster of Muhibur Rahman, MUHIBUR Rahman MV School on 22/04/2007, which was forwarded by the headmaster to the district elementary education officer on 24/4/2007. Next paragraph. Here is said discrepancy, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned additional senior government advocate. As well as Ms. S. Shruti, standing counsel for the school education department, in course of the day. Next, the records produced are returned to enable the state to file affidavit in opposition in the matter. So the respondent state shall also produce a copy of the application filed by the petitioner for appointment on compassionate ground. List after 4 weeks. File an affidavit here. You have to produce the records. You can annex it. 54.
Supplementary item 54.
You got the information. This elementary will be appearing. This is a institution within the Orang National Park.
Sorry, I'll skip that. Launch, you can take up next week, we'll get the instructions.
See our last order.
He take some difficulty he could not come in the first time. So where probably he asked the question. Just have a talk with him.
Tell us at by 2 o'clock.
F2, sir. F2.
55.
Because it could be otherwise in contempt to the Supreme Court of directions where
Exit.
that's why this observation.
Yes.
Background is that.
Yes.
55. Yes. Yes. Who is appearing for the respondents here? Education, secondary education. It appears that the order passed amounts to overreach of the order of the court. You have to also issue notice why so much contempt should not be drawn up. Give him a copy, show that order, show him that order. You see, I'll tell you what has happened. In this case, the petitioner was suspended. His suspension order was set aside by this court. And he was reinstated in his post. He was headmaster. He was allowed to join sometime in May. Dates I will not remember. And in November, he was demoted to the post of assistant teacher. So the question is whether you are punishing him for coming to court.
Things that the director order Is with the approval of the government and the promotion has been cancelled and accordingly, my lord, a fresh selection has been directed.
We have to state none.
Page 77 last.
No, that's what we are saying. We'll have to state then. You look at the order of this court. That is at page. Where is the previous order of the High Court?
Page 73.
74.
That was in respect of the suspension. My lord.
It's
The
okay.
suspension was reinstated.
No, you see, come to para 9 of page 74.
However, it is left to the wisdom of the respondent authority to proceed further regarding the disciplinary proceeding initiated against the petitioner. The same is not interpreted by the court. My lord,
So now you see, where it come to page 77. All this does not show that the disciplinary proceeding was brought to an end. Because if it is a disciplinary proceeding initiated by the Secretary Education Department, Secretary will not be the disciplinary authority.
it would be the director of secretary.
So therefore,
The secretary's, this is a communication to the
no,
director.
you are not getting it, Mr. Kaushik. Page 77, look at the reference, cancellation of promotion.
Cancellation of promotion from one.
So it doesn't say disciplinary affirmation of the disciplinary proceeding.
It is not a
So
punishment as under the Assam disciplinary appeal rules.
for that you can't, you have to say something more. Proposal is for cancellation. Why should we read something more?
It's the para 9, page 74, the disciplinary proceeding which has been initiated against the petitioner.
No, in a
Yes.
disciplinary proceeding, what do you do? In a disciplinary proceeding, you will giving the punishment which is provided under section rule 9. Does it envisage cancellation or promotion?
And my lord, this page 77, my lord, doesn't appears to be a punishment under the disciplinary appeal.
What do you call, there is a old kindergarten poem. It can be twisted and sung like this. Catch a person by his throat if he goes to agitate in court.
And you see that there, page 77, the reference number. There is some later,
Cancellation or promotion?
that is a subject, my lord, the reference.
Your letter number so and so dated 23.
There is some letter of the
No.
director.
First of all, in your department, is a disciplinary order passed by a competent authority, which should be director. Is it required to be confirmed by the secretary?
Not necessary.
Not necessary.
Not necessary. But
So-
my lord, the headmaster under the rules, though is appointed by the director, but the selection is approved by the government. And therefore, my lord, to cancel the promotion order to the post of headmaster also, the approval has to be taken from the
No,
government.
you see, first of all, who is the disciplinary authority of that
My lord,
headmaster?
that is what I'm trying to, my lord, page 77.
And there at page 77.
Yes, that doesn't, it doesn't appear to be an order that is passed under a disciplinary proceeding.
That's what I'm saying. That's why that poem, catch a person by his throat if he goes to the court.
This, if we find out, Malad, if I'd like to find out this, Malad, the reference letter, allegation, GB, ESC, DSC allegation dated 3/2/2023. This probably is a director's letter written to the government for approving the cancellation of the promotion.
You see, uh, you know the procedure more than me.
Right.
You know my limitations in what you call disciplinary proceeding. I have certain limitations, but you know more about that. Now, in a disciplinary proceeding, you give a punishment, and therefore you will say that you are punished with the with the with so and so demotion. You will say it is a punishment, and then you will say it is a punishment within the meaning of Rule 9 of the Disciplinary Service and Appeal Rules. That is number one. Number two, before taking that step, you'll also be required to issue a notice, second notice,
We'll
bring
have
it to a
follow the
logical
entire
condition.
entire procedure.
Proceeding has to be done. Now, from this letter, it doesn't appear.
It doesn't.
Therefore, why we should not issue a notice, that why you should not be what you call you'll have to explain your conduct in penalizing the petitioner as a measure of overreaching the order of the court. I'll stay this and I'll put that question.
Fine.
If you can't satisfy, then we issue the
We'll try.
we go ahead. Mr. S. Bhattacharya, counsel for the petitioner, and Mr. B. Kaushik Leonard, standing counsel for the secondary education department. Next paragraph. In brief, the case of the petitioner is that this court by order dated 3/5/2023 passed in WPC 430 of 2021, had set aside the order of suspension of the petitioner, and the respondent authorities were directed to reinstate the petitioner in service. First of all, at the relevant point of time, the petitioner was the headmaster of the particular school. Full stop. It is projected that on 6/5/2023, the order of the court was submitted before the authorities, and thereafter by order dated 11/10/2023, the director, the deputy secretary to the government of Assam, secondary education department, had approved the communication by the director of secondary education Assam from cancelling the promotion of the petitioner and issuance of a fresh selection process for the headmaster of the said school. Full stop. Hence, next para. Hence, issue notice returnable. Issue notice, including notice on the prayer for interim relief, returnable in 4 weeks. The petitioner shall the requisite extra copies of the petition is served on the learned standing counsel for the respondents in course of the day. Next para. The director of secretary education Assam, shall is directed to show cause as to why his action in demoting the petitioner from headmaster to assistant teacher shall not be construed as an act of overreaching the order of this court referred above. Full stop. If he is also put to notice that in the event the show cause reply is not found acceptable, the court may pass appropriate orders as may be permitted in law. for making an attempt to overreach the orders of the court. Next para, list after 4 weeks. Just before that, you say that they done it standing counsel for the school education department, secondary education department shall send a rounded copy of the order to the respondents. Okay, next para. In the as an interim measure until the next returnable date, comma, the respondents are jointly and severally restrained from proceeding with the selection from finalizing any selection process for the post of headmaster of
Jonathan High School.
what is the name? Janata High School, JNATA High School, Tiok. That's all. Oh, then you'll have to give a certified copy. First, in the meanwhile, the petitioner shall also produce a certified copy of the order before the director of secondary education assigned.
Supply item 56.
The matter pertains to lawful nomination of members by.
Yes. It says your rule says that unless it is recommended, you can't appoint.
Page 32 is clear, Milord. 4 members be nominated by the.
But it's your rule says he is somewhere it is referred. The rule says that unless it is, it will not be done unless it is recommended by the school.
That follows concept. Page 36, Milord.
36.
There are 2 clear criteria. One, biodata have to be furnished, indicating his or her competence of the college, as well as the non-affiliation to any political party. First, page 36.
Yes.
And second one, minimum at least 5 persons' names should be forward. Not in the, this page 37 and 38, not in him.
Yes, 5%. Okay.
Kindly turn to page 37.
30.
37, resolution of the college. Only 4 names here. 37 and 38. There should be at least 5%.
No, you can return it, but how can you nominate people who are not in the list?
But by
That will be violation of clause 5. Please don't interrupt. That is something I would dislike. I am impatient when somebody tries to disrupt the questions which I am putting and which Mr. Fukan is sufficiently senior to you. Correct. Don't overreach. Don't interrupt when I am putting a question to the council and he is making a response. Not be appreciated.
Below paragraph 1, below page 36.
37.
36.
36, I am there.
The 2 criteria below biodata regarding
Yes.
contribution and non-affiliation to the political party.
Yes.
And second one, the last but 3 lines below, at least 5%.
No, it's okay.
Now, page 37. Resolution number 1. The GP, page 37.
Yes.
The GP adopts the resolution unanimously. 4 persons' names have been incorporated, not 5. Now, page 30.
30.
38
Yes.
and 39 Miller. 39 would be more appropriate Miller. It has been addressed to the register Guwahati University by the principal. 4 names have been given without any biodata, without any indication regarding non-affiliation to any political party, and without incorporating minimum 5. So, the resolution has been taken in the month of October. And in the month of March, the Guwahati University nominated 4 persons. There may be some communication in the meanwhile, 6 months. Not before this on report.
So, my lord, at this stage, office may go, my lord, and I will obtain the certificate. Resolutions and communications have been made in the month of October. After 6 months, register issued the letter.
But what happens to these two people who are,
It is not clear from the receipt, sir, but it is right, but I have to obtain instruction. I see there are some communications.
but if there is no communication, we will give a conditional stay. And these two people should not be a member of the,
Apparently, yes.
if there is a communication, we will protect it. If there is no communication, then they will not function as the member of GB. We're protecting both the interests of both of you. Your name? Mr. A. Barwar and counsel for the petitioner. And Mr. PJ
1, 2, and 3.
Ugandan, it's standing counsel for Bharati University, paying for respondent number 1, 2, and 3. Next pattern. The inclusion of names of respondent number 4 and 5 as members of the governing body of Bajali, BAJALI, teachers, after that apostrophe, training college. Is assailed in this petition filed under Article 226 of the Constitution of India on the ground that their names were not recommended by the
Registered court.
by the college. They'll have to be nominated by the college. Or by the college. Which is alleged to be in violation of the communication dated 14/2/2012 by the Guwahati University, by the registrar, Guwahati University, laying down the criteria for considering proposal of colleges for nomination of university nominees to the governing bodies. Next paragraph. The learned standing counsel for the respondent numbers 1, 2, and 3 has referred to Annexure 3 and 4 of the writ petition, and it is submitted that that instead of forwarding 5 names as required by the communication dated 14/2/2012, the college authorities had forwarded only 4 names, which was not accompanied with biodata of the proposed members and
Indicating their contribution.
and indicating their indicating
Their contribution to the collision, first line.
Huh?
First line, paragraph 1. Page 36. Paragraph
or their contribution in the college,
as well as
as well as whether or not they had political affiliation. Accordingly, it is submitted that there might have been some communication before this approval was granted. Next, issue notice returnable in 4 weeks requisite extra copies of the writ petition be served on the learned standing counsel for the university for the respondent numbers 1, 2, and 3 in course of the day. Next para. The petitioner shall take steps within 2 days for service of notice on respondent numbers 4 and 5 by registered post with AD. Next para. As an interim measure until the next return live date, comma, it is provided that in the event there has been no exchange of communication between the Guwahati University and the Bajali Teachers Training College on the recommendation of names of respondent number 4 and 5, comma, the operation of the impugn communication bearing memo number so at page 40, memo number so and so dated 17/3 is down below. Shall remain suspended insofar as respondent insofar as the names of respondent numbers 4 and 5 are concerned. Just however, comma, it is clarified that in the event the decision of the Guwahati University as communicated by communication dated 17th, impugn communication dated 17/3/2023 was
It should be 22/3. Was the next day, days 41. Was modified. 17.
oh, page 41, not page 40, 41. Page 41. In the event the names of respondent numbers 4 and 5 was approved after communication exchange between the Guwahati University and the Bajari Teachers Training College, comma. There should be no suspension of the impugn order dated dated 22/3 to the 22/3/2023 within bracket annexure 6. Next paragraph, the petitioner shall serve a certified copy of the order before the respondent authorities to bring the order to the notice of the said authority. It's a conditional stay. They start for 4 weeks.
The government body held a meeting.
No, if it is if it does not have quorum, you can't do it.
6 members are needed.
Quorum requires 6%. Automatically, Miller.
It will not be. It can't be held.
Could be held. It could be held, Miller.
No,
It
if
requires 6%. The page 32 is clear, Miller. There is more than near about 20%. There are near about 20% constituting
they are
the.
near about 20%, then you hold it. You don't need a clarification from the court then.
Quorum.
57. Yeah, Mr. Kaushik, you are appearing in the matter. Is it required that this any observer from the education department is required?
That is required.
It is required.
Basic grievance of the petitioner is.
No, it's okay. Then we hear Mr. Mahmood,
Fine.
because that is the query.
Letter of the review of this 23
20, which page? Give me the page number. 23. Yes.
is our grievance. Right before the deputy commissioner. That the managing committee of Konabibi and this was constituted illegal in violation of the rules of 2011. Thereafter, when the DO carried the matter
and found that there were irregularities. So he filed a lot of test petition. From Sri Vipin Kumar Nath, CEO, the headmaster Sholai Vivi MPSK. Where he have instructed to call a fresh general meeting for conversion of issue management committee within 7 days from the date of issue of the letter, as the complaint not has been noted people parents of students. That earlier meeting held on 17th and February is not free and fair manner, and also departmental observer has not present at the meeting. Some of the new act the headmaster to constitute new assets. And pursuant to that order letter, that copy of that order was also sent to the PO. Now can you see it in 28? After receiving this, PO wrote a letter on 30/10/2023 asking the headmaster to contribute a press conference. Suddenly, when these things, nothing were done, all of a sudden the PO and headmaster made a understanding among themselves and passed an order, can you see August 29? And exactly. It says that to the DO regarding school management committee as concerns NIBB and LPC. With reference to the subject, I have promised to submit herein an application and with other related documents. Received from up to missing 92 others. For approval of the school managing committee of NIBB, LP school, which is constituted by election on 5/10/2020. So when in 5/10/2023, there was no meeting at all. Some persons at the after and BO has made a imaginary committee and strategic representation. Now the should kindly see when the meeting of 17 and 23 has been cancelled. If there was a committee on 5/10/2023, how this letter was sent? So this is an imaginary committee which has been shown as constituted and to get the headmaster and the PO, and that's why they have been made a correspondent by name. And this PO is also creating committee disturbing what's in the law that enter education that particular information. So we have made him as the headmaster as the respondent by name. That lordship may kindly see.
First is, Mr. Mahmood, you'll have to satisfy the court on the maintainability in light of Order 1 Rule 8 CPC. Because you say that you have been authorized by many people to represent them. Now, if you are in a representative capacity, no, it's okay. But if you are suing in their representative capacity, then you have to give a newspaper advertisement informing that you have been litigating on behalf of them. Because there are 92 people who are given a representation. Now, if I am to take a hearing, this 92 people will have to be notified. Otherwise, you have another way to make a representation against the representation of the at page 29 before the BEO. But the problem is that the court, when you are acting in representative capacity, you'll have to ascertain that you have that you have been authorized.
Then anybody may file a case.
No, I'm not saying you can't. Have I said you can't? I don't say that. No. You see, representative capacity should, whenever I fail anywhere else, I come back to my alma mater, that is CPC. If I, what you call, in the boxing, if you can't go below the belt. No, I'm not saying, you see, I'm not, have I said it is not illegal?
And there is a violation of rule 13 B Roman 3. So anybody may result in such action of.
It doesn't take us anywhere. Just that's CPC जाते हैं CPC. No, it's not a question of that. No, it's not a question of that. Because there are certain things which are ingrained. I can't, what you call, if I I will have to have a reasoning before I overcome my own, what you call this, prejudice against, in respect of the CPC outside my mind. Order 1 Rule 8, come to sub rule 2. Order 1 Rule 8 is one person may sue or defend on behalf of all in the same interest. And at times in the even in the writ court, the principles of CPC will be applicable when it comes to suing in a representative capacity. Order 1 Rule 8, A and B we can omit of 1 and come to 2. The court shall, in every case where a permission or direction is given under sub rule 1 at the plaintiff's expense, give notice of the institution of the suit to all persons so interested, either by personal service or where by reason of the number of persons or other cause such service is not reasonably practical, by public advertisement as the court in each case may direct. In a writ petition, I have seen advertisements coming out in court that so and so has been raised, issue has been raised, and therefore if somebody wants to join, he can do so. Because in Assam Tribune, off and on, you will find that advertisement coming. So the basis is Order 1 Rule 8(2). Because if you are doing in your individual capacity, we will take it up. But once you make a statement that you are authorized by other persons, because you see, then what happens is that if a school, 92 people have given an application, and if I pass an order staying anything, we will have 92 aggrieved persons.
If there is a meeting,
No, you see, that can be challenged. That can be challenged when this order will be passed. But now you see, it is in consideration of the BEO. You can represent before the BEO and end of the matter. But if I entertain a writ petition, when there are 92 complainants, but there are 92 persons who have given an application. If I pass an order, there will be 92 applicants who will be aggrieved. And if these 92 people are themselves fighting with each other, they will file 92 applications for modifying of my order. No, Mr. Mahmood, for a moment I am not saying that you are wrong. Huh?
and since some decision is taken by authority, you are actually.
No.
If I may point out on page 20,
No tail with the order.
page 29, which my senior is agreed with. This is a forwarding of the complaint which was received by the BO to the DEO.
But
No,
that you
no,
is
that's
the-
okay. But Mr. Mahmood has otherwise made out a strong case.
No. This page 27, DEO has already taken note of the complaints which has been filed, and therefore a meeting has been called for a fresh selection.
But you see that the dates are relevant, 17/10. And if they say 5/10, there was a meeting.
So my lord, the DEO's letter forwarding it to the DEO, DEO will take note of everything.
That's why we are representing and ending the matter. We are not attending that liberty we are granting. Mr. M.U. Mahmood, learned counsel for the petitioner, as well as Mr. V. Kaushik, learned standing counsel for the Elementary Education Department, representing respondent numbers
1, 4, 5.
And Mr. V. Chaudhary Lalit, done a standing question for respondent number 2, as well as Mr. P. Saikar and government advocate appearing for respondent number 3. Next paragraph. After some deliberation, the learned counsel for the petitioner seeks permission to withdraw this writ petition with liberty to submit representation before the district elementary education officer, Nagaon.
Okay. Okay. Now, in charge is you Hosai at Nagang. The DO of Nagang is holding 2 charges.
2 charges.
No.
But what will indicate DO Zion?
I'll have to indicate he is holding charge. Tomorrow he may not be holding a charge, so that won't go. District elementary education officer. You see, a man may be a peon, come managing director of a company. But if you are addressing to the managing director, it will be managing director. He'll take care of it, even if he's a peon. But if a managing director comes, then peon will be peon and managing director will be different. First off, in this connection, it is pointed out that the block elementary education officer by communication dated 30/10/2023 has already has already made certain instructions to the headmaster of Sonai, SONAIBIBI, Sonai BB LP school, and that the communication dated 31/10/2023 regarding school management committee would be contrary to the to his previous communication dated 30/10/2023. Correct? Oh, okay. As well as it would be contrary to the communication dated 26/10/2023 within bracket Annexure 4 by the district elementary education officer, Nagaon. That just add that 31/10 is Annexure 6. 30/10/2023 is Annexure 5. With liberty is paid for, this reparation stands closed. Yes. Can't help it. Yes, I have indicated. At times I can't, I've lost my hair, but I can't lose that CBC inside.
Attention is given to the passport. I think that was, but in the order I see that order is not there. So the second one.
No, we may make mistakes, but if you point it out, we'll rectify it. You see, no, Mr. Mahmood, I'm not infallible. But you see, the amount of orders we are required to pass, check, recheck, and sign. So you see, there are 50 orders. I end up looking up at 150 orders. There will be first correction, there will be second correction, and then we sign it. And you mind it, this thing ends at about 7:30 every day. My 3 secretaries are attached to me, and I, along with my usher and my law clerk, from 10 o'clock to about 7 o'clock, 7:30. You do the same thing every day. And there are chances that we miss out something. There may be a major fault in the order. It may happen. Please point it out, we'll rectify it. In my court, I have also permitted, if you have not taken certified copies, if you approach the court master, it is referred to me. If you have taken certified copies, you return it back, we'll make that necessary corrections by correction slip. But if, because we can't have two orders in the board. If you have taken out one certified copy, I can't rectify my order then we have to file an application for a correction. These are certain mistakes I'll have to live with it till I superannuate. We make mistakes, but it is due to that we become mechanical at point of time. There are mistakes which are there we can't read. But if the same mistake you make, I'll be able to look at it. But if I make my own mistake, it doesn't catch the eye. So that's why we need somebody else to revise. In normal examination, a student who gives the exam revises. But in my work, if I do the revision, I don't find that mistake. That's the big problem. But if others do the mistake, I will find it out. In a repetition, if you make a mistake, even a comma or full stop, it catches my eye. But my own mistake, I can't see. Despite spectacles. Continue to.
Supplementary item 54.
Was there?
Yes.
Earlier it was within the meditation area.
Just a moment. Where is the 610 letter order? Where is that 610 order? Indian order, which page? $25. Just a moment.
That will be.
Yes.
study page number 16, okay? 11/9/2023.
Page number
16.
16. Yes.
They were directed to 15 for establish Mugaloti farm.
Serial number?
Serial number 11.
Serial number 11. Yes. Okay.
As per proper verification and finding the report from the district commissioner.
Okay.
I combined the sale order of 215 our school to the and we have also constituted the managing committee notice and other verification report notice finding spot verification notice. We have reestablished our school office to the new place. And
Which is that new place? Which is that new place? What is the name? Okay. So now what do you want?
also we checking to once if the practical order. Just because we earlier finding report and proper spot verification of the authority has satisfied and directed to reestablish the school law. So at least lordship, if lordship we bound to 15 school law, at least necessary time we may be given law. That's because the students who are below 14 years, class 16, class 1 to 5. So lordship now new place lordship, which is directed by the authority of for 15. It is 2 months in there, almost 7 to 9, 7 to 8 kilometers.
No. Just a moment. Let me understand. It's confusing. Number one, at page 16, you say you were directed to shift to Hugaltoli, Hugaltoli. Hugaltoli. But you have not shifted to Hugaltoli. You have shifted to Sutiagaon, Sutiagaon, right? But then it is a non-compliance of order at page 16. That's number one. And number two, if that area is within the original school location at Goribor Char, that was under Orang National Park. So activity under Orang National Park is not permitted. So if you are shifted to this place, page 16, no, please be sure. I don't think you have been instructed rightly. You show it to him. See the next page, second page. The authorities are saying that your school is in Sutiargaon. If it is there, no. You see second page. Have you read the second page? The authorities say you have set up your school in Sutiargaon. Now you want us to stay that order. That means the school will be closed down. Are you instructed properly? I just adjourn the matter, take instructions. Mr. B. Kaushik, learned counsel, learned. Sorry, the learned training counsel for the elementary education department, comma, pursuant to order dated 8/11/2023 passed by this court, comma, has produced a copy of communication dated 9/11/2023 and two letters dated 9/11/2023 to project that the school, namely Goribor, Goribor, Goribor Char, CHAR, LP school, was originally located inside the second edition, second SCCOND, second edition of Orang National Park, and the block elementary education, block mission coordinator, Lahorighat, LAHARIGHAT, SSA Morigaon, has reported to the block elementary education officer, block mission coordinator within bracket SSA, that after eviction of the school, it has been re-established at Sutia Gaon, SUTIAGAON, Gaon Char, CHAR, which is outside Orang National Park. Full stop. Therefore, the nature of prayer made in this repetition is found to be not in consonance with the instructions produced by the learned study council for the elementary education department. So next para, accordingly, Mr. M. Saikyal and counsel for the petitioner seeks some time to obtain instructions. List after a week.
Time being item 6.
The copy of communication produced by the learned standing council of the elementary education department is written as a part of record. List after a week. 6.
I'm very sorry, my lord. In this matter, we forget to communicate with the deputy commissioner. Today, later already drafted in the file, but no comment. Today only I communicated with the deputy.
When do you expect the instructions?
10 days.
Within 10 days. Okay. Mrs. S.B. Chaudhary, counsel for the petitioner, is present. Next, Mr. P. Saikyal, and government advocate, prays for 10 days time to obtain instructions as indicated in the order dated 4/10/2023. Next, list on. Give a date. 20? 24. 23rd is a Thursday. Oh, Friday. 24th is Friday, not 23rd, 24th. Okay.
Time being item 9.
Okay, okay. I get it. Then I'm issuing a notice that there is an interim order which will be what you call kept alive till the next date.
Yeah, he is for a commission. Today only I came to know about the case.
Pardon me?
Today only I came to know about the case.
No, I understand. So I'm issuing a notice and the interim stay is extended. There's an interim order that since his cutoff, OBC cutoff mark was 111, and therefore he should have been recommended. That's the Mr. S. N. Krishna Tiyar, and counsel for the petitioner. Also heard Mr. SMT for education who will be appearing.
We are not a party in this petition. Our name is wrongly.
Oh, acha, okay. Mr. Vikram Chaudhary, learned standing counsel for the
SLRC grade 3.
huh?
State level recruitment commission for class 3 post.
No, that is respondent number
Lordship,
1 and 2.
1 and 2.
1 and 2. For the State Information Commission, government will appear. State Information Commission. Huh? Oh, this is Sabah. Oh, okay. None of person called for the respondent numbers 3 and 4. Next para. If you notice a motion returnable in 4 weeks. So requisite extra copies of the declaration be served on the learned standing counsel for the respondent numbers 1 and 2, as well as on the respondent numbers 3 and 4 within 2 days. Next para. This court by order dated 18/10/2023 found prima facie case in favor of the petitioner, and accordingly direction is issued that to the effect that one post of grade 3 Roman 3 in respect of the advertisement at page 26 within bracket annexure 5 to the writ petition bracket closed shall be kept vacant until further orders. First of the as an interim measure, they said interim order stands extended till the next date of listing. List after 4 weeks. So you have to communicate. You have given certified copies to the authorities. No, but then they will not maintain it. The petitioner shall produce a certified copy of the order before whom?
Lordship, it will be secretary.
Respondent number 2.
2.
Before the respondent number 2. Next list after 4 weeks. Oh, acha,
Yes.
okay. The registry shall reflect the name of SC, SCBA and SC,
SLRC grade
SLRC
RC grade 3.
within bracket grade 3. Instead of SC secondary education while listing the matter next.
Supply item 58.
You have to permit them to give the examination. The results you can keep on hold.
Because I was just told that firstly, my lord, the exams are starting from 19th and will be continuing to 25th. Secondly, my lord, that there is 75% attendance requirement. Which I
So if has been restricted, 75% will not be there.
this is the reason, my lord, they may be otherwise not eligible for sitting in the exam.
You keep it on hold. You allow him to sit in the examination. The results you keep in the seal cover. Don't declare
My
it.
lord, because this matter is on 9th, exam will start 19th, my lord. If my lord give me 2 days of time, like on 15th May, I will place everything record in a small affidavit also. That's not.
No, we are not saying that he has a right. The right will decide when you file your affidavits. But for the time being, let the exams. He has been rusticated.
Yes.
Now he says, you see, he says that you have filed. He has filed an appeal. Correct. His appeal you are not deciding for a month. That is your appellate authority's fault. He has been rusticated. He has been what you call. He has been removed from the IIT.
Because the moment the next BOG meeting happens, they will place it before the BOG.
No, I understand, but till then you allow him to give the examination. You can keep the answer, the results on hold. You don't declare the result. And in the meantime, if your appellate authority decides otherwise, writ petition becomes infructuous. Then he'll have to challenge the appellate authority's decision. You see, in a student life, people may, they are, I can't, what you call, vouch or give a guarantee that I was not disobedient in my college time or school time. We have hidden many things under the carpet. When we were college students, school going students, college going students, many things are inside the carpet.
My instructions were to oppose them on the ground that there
It is only when what you call this graying has started, then we are compelled to be bound by the limits. But otherwise, school, college days, people are boys and girls, they make mistakes.
That's a huge fight, my lord, where the Laches were also apparently injured and. But my lord decided.
No, I'm not saying I'm deciding it. I'm not saying he's beyond reprehension. You can't reprimand him or you can't rusticate him. But you see, your appellate authority has been given this appeal long back, about a month back now.
That is actually, my lord, director was not there.
I understand. Did I say that the director has to be compelled to sit and do work? No. Even yesterday I said, I would appreciate if the authorities come up with a award, something like Vishisht Seva Medal for people who don't work.
The previous director was promoted, man. Then
No, I'm not even suggesting. Even I'm suggesting otherwise. I would be happy to see an award given to people who don't work. But then at least I can save some of my time. 4:15 means 4:15. I'll rise up. 4:30 in the afternoon. In the summer timing, I will rise up. No extra work. 4:16, I'll be leaving for home. I'll be so happy to see people being awarded for doing no work. But he's a student. What can he do? He gave a what do you call appeal. He has been rusticated. He's been removed from the first year admission. He's been cancelled, and he can't do anything. He just can't go and give attendance. If I am the teacher, I will not take his attendance when the college IIT has removed him. So he fails in the what you call in his percentage of attendance. Now he has filed an appeal. The director doesn't pass on order for whatever reason. He may not be in chair. He may not been appointed. Seat is vacant, but he has filed an appeal. Let him sit in the exams. If you, in the meantime, if your director can dispose it off, well and good. You keep the results on hold. You don't declare his result. Let him sit. You see, a student's career, if he's in IIT, he would be a brilliant person otherwise. Correct. And you please also know a fact. I am saying it fact with some responsibility. Amongst all other streams of education, medical, what you call this MBA or any other stream you can think of. And if you compare it with engineering, most of the rowdiness happens more in the engineering college than in medical college or in any other stream of education. There's some experience I have gained in looking at things in these 5-6 years. Number two, you'll hardly come across people who are in the physics stream and what you call in the they have passed out through physics stream and they have been caught in any antisocial what you call happening. Let it be corruption, let it be so and so. You just take the file and look at the physics people. There'll be a class different. Thirdly, if you find a what you call a very high standard of what you call crime. I'm not saying that word because I'm online. I will be misconstrued. But there's only one stream where you will find that people who are excellent in one specified stream of education, white collar crime is high. Just give me a general statement. Engineering people are involved in rowdiness. Even in Guwahati, you visit the campus, you are of a person of Guwahati, you will know more. People make mistakes. He has got a suffering. He has filed an appeal. You decide the appeal. Doesn't matter. Student career is something which spoils the life of the entire. If you dispose his appeal, he would not have been here. Then he would have been challenging the appellate order. Please understand this. Student life is very, and especially engineering. From? Okay. Okay. 16 and
58 and 59.
they are
Start from tomorrow, that examination, and
okay. Okay. Okay, we'll record his objection, but we'll grant that interim order. That is CKR learned counsel for the petitioner and Mr. A.B. Day learned standing counsel for the respondent number 2 to 5. CGC will be appearing. Mr. Gogoi was here. Can we record his name? K. Gogoi? Huh? You'll inform him? Okay. Mr. K. Gogoi is CGC for respondent number 1. Next para. The petitioner was pursuing his third year in civil engineering in the IIT Guwahati, was expelled for 1 academic year by holding him to be involved in the said incident. Full stop. Against the order expelling him from IIT, the petitioner has filed an appeal on 4/10/2023 before the appellate authority, which is stated to be the director IIT.
It will be BOG. It will be BOG, but it goes through the director. He has filed it before the director, but it is the board of governors.
Acha, okay. Who is stated to be the board of governors? However, the said appeal has not yet been adjudicated and decided. However, the petitioner claims that the examinations for the third year in civil engineering would commence from 11/11/2023 in respect of lab examinations, and the text, the subject examinations will be held from 19/11/2023. Next para. The learned counsel for the respondent numbers 2 to 5 has objected to the prayer for interim relief on the ground that the petitioner was found to be involved in a fight between 2 groups, out of which one group was local residents.
There were 3 groups, my lord.
I said three groups. Okay, 3 groups, out of which one was local residents, and therefore the the students' disciplinary committee, after granting opportunity to the petitioner to show cause, was given the punishment of expelling him for 1 academic year. So it is submitted that the the director IIT was not available.
Director, IIT was the post fell vacant, my lord. because
The
order was
post
not
fell vacant, for which the appellate authority has not been able to.
The appellate had not seat also. The BOG has
That's
not.
what I'm saying. Let me complete. Has not been able to hold his sitting. First of, nonetheless, committee submitted that as the petitioner is involved in violation of the code of conduct for the students, he is not entitled to any interim relief. Next para. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned standing counsel for the respondent numbers 2 to 5, as well as to the learned CEC for respondent number 1 in within 2 days. You give it today, in course of the day today. Next para. On a consideration of the prayer for interim relief, the court is inclined to provide that the respondent number 2, i.e. the IIT Guwahati, shall permit the petitioner to appear in the third-year degree examination in civil engineering, which is slated to commence from 11/11/2023. So, however, the respondent number 2 has the authority, has the liberty to withhold the result and keep it in a seal cover without declaring the result. Next para. Liberty is also granted to the appellate authority of the IIT Guwahati to adjudicate and decide the appeal of the petitioner filed on 4/10/2023. First of all, the declaration of result would be subject to outcome of the decision of the appellate authority. Correct? Next para. It may be late by the time the order is released, and the petitioner may not be able to obtain the certified copy in course of the day. So therefore, the petitioner is permitted to serve a downloaded copy of this order on the respondent authorities, and the who is the person to whom is to be given?
I will also intimate the authorities.
No, that's okay, but he'll have to, when he goes to the university, he'll have to give it to someone. To whom?
To respond number 5, my lord, joint register of HOS and student affairs.
Oh, okay. To the respondent of 5,
And to the registrar of IIT Guwahati.
as well as to the registrar IIT Guwahati. And the said authorities would have liberty to compare the downloaded copy from the website of the court and act accordingly. List after 4 weeks. Next, just say before that, liberty is granted to the respondents to make a mention for out of turn listing if so required. Next, otherwise list on 4/11/2023. Sorry, I left out for 4 weeks. You're giving you liberty to make a mention if required. He's a PhD student. Okay. 59 is same. Third year?
No, my lord, he is the student.
No, 59 is third year. Okay, 59 is same. 60 is PhD.
The allegations are more grave against it.
Is it?
Yes, my
Sure.
lord. he has apparently hit an junior student. Two of his tooths have come out. So that, and the nose have also broken. That
No. Conduct is not only inside the campus. Even outside the campus is a serious kind of misconduct. No, just show me that that part.
it is not part of it. It's a part of the SDC minutes which I have with me. But then,
No, that may be so, but from where do you say that this that the incident never happened? Shows that. So they did that. You take that also.
Yeah, very big.
it's my with the SDC minutes.
All these 13 boys and girls, against them
16
action is taken,
Same action has been taken against all. All have been.
all of them. So it is a
Only
self-serving
one guy.
statement. So this will be a self-serving statement. No, because you see, Mr. Cal, it's a common example I give in many of the cases. I have repeated this more than 100 times, but I am still repeating it again. You see, X comes to court and says that he is the President of India. He gives his own affidavit that he is the President of India. He gets endorsement from 100 citizens of various parts of the country saying that they all know that this man X is a President of India. And then he files a writ petition or a suit claiming that, well, I have statements of 100 people who know that I am a President of India and therefore please permit me to go and occupy that chair. So it is a self-serving statement.
Page number 7, my lord, for a moment, just one line I'll show it. Page number 7, my lord, is the SDC minute can be looked into. Dipanshu Popare, the item number 9, he is also the victim, my lord. And the last line, as per the Dipanshu,
Page, just page
7, my lord.
page 7.
Everyone's role has been picked out and their statement. As per the Dipanshu, my lord, item number 9, the last line in the paragraph, my lord. So he states that Rohitash and he was involved. As per Dipanshu and the evidence that could be seen, he has fractured his
I'm not
nose.
able to get it. Where you are looking?
Page number 7, my lord.
Paragraph 9.
9.
Yes.
Dipanshu Popare is the guy
Yes.
who was
Okay.
also involved with the Rohitash. So it states, as per his statement on 08/8/2023, he was not present at the ghat and he does not know what racial slurs were used. He does not want to put any specific person. He still feels Rohitash and Shashikum are to be blamed for all the unrest that took place. In his second statement, he mentioned that he went to ghat to consume alcohol with Pradyum, Mr. Yashraj, Gaurav, Aman, Adesh, and Mr. Vivek, etc. After some time, a fight broke out between Mr. Pradyum and Rohitash. He went to see, but was beaten by Mr. Rohitash on his face. As he was leaving the ghat, he abused Mr. Rohitash and asked why he hit him. He said that he never had an intention to fight. The locals get into fight. When he reached campus, he sent WhatsApp messages to his Disang students to reach at KB gate with sticks. He says that he did this for self-defense as he was already brutally beaten and waited for Mr. Rohitash to settle the matter. Mr. Rohitash entered the campus through KB gate and went straight to the Lohit hostel. After that, Mr. Dipanshu went to Lohit hostel to ask why Mr. Rohitash was fighting with him. He then went to hospital for medication. As per Dipanshu and the evidence that could be seen, he has fractured in his nose and 3 of his tooth were broken during the incident. So Similarly, my lord, rule of 13 students, 16 students have been, as per their statement, have been looked into. Video evidences are also been looked into. My lord may also look into the page number 18.
Okay, if he is a PhD student, then that means no exams. Only his periodical evaluation is to be done.
A senior man
No,
also, my
but
lord, getting a
if he
senior-
has
senior
assaulted
man.
and broken the tooth, we are not giving him that interim relief. No, you see, that may be there, whatever is there, but this is the minutes. They may have made a mistake there, but we'll provide that, what do you call this, if he misses his examination before before the appeal is disposed of, then he'll be given an opportunity to give an examination.
My lord,
No, if his appeal is decided against, in favor of him, then he has to give an examination. Then you'll have to conduct an examination for him, specific. So, we'll protect you in that way. No, because you see, in incidents where this is pointed out of breaking open a tooth, you'll find a judgment of the Supreme Court in the first part of this 2023. It says that the courts should normally not, in a disciplinary action, come and interfere. No, no.
he's a PhD student, my lord, and he's hitting this, it just qualified young boys in such a manner. He took them to drinking and all. He admits, my lord.
Just one.
And that
But this order would not help you. No, that is okay, but here, after disciplinary action, he has been. That's okay, but you see, here it's not a case where under the disciplinary proceedings that students was restricted from the college. That's not there. Hmm? No. No, but in this case, there is a proceedings drawn up under the statute. No, we are protecting you. We are saying that subject to disciplinary proceeding, you will be permitted to give your examinations subsequently. This is you are a PhD student. That's the difficulty. And the more we read, more confusing it becomes. Because when it comes to students, we want to give them benefit, but Supreme Court says that no, after a disciplinary proceeding, hands of this the High Court the court should not interfere with the disciplinary. It is, and this what is the Supreme Court is that there's some word. Discipline inside a campus is necessary. That's the. Okay. In the third case, that he is a PhD student, and therefore the disciplinary authority shall make an endeavor to how much time? Director is not yet appointed.
Directors are now appointed on probably weeks back. Last week he was been appointed.
Okay.
Charge has been actually given
So
by.
say that it is considering that the petitioner is a PhD scholar, it is provided that in the event the appeal is decided, the appeal filed by the appellant if a petitioner is decided in his favor, the authorities shall permit him to appear in the PhD. No, in PhD you have an examination. No, your thesis is evaluated. Oh, okay, PhD examination. Okay, PhD examination by holding a special examination for him, relatable to the present academic year. Otherwise, there will be a gap. Whenever the exams are held, relate to this academic year.
Yes, my lord.
No. I'm trying to understand. PhD course is a time-bound course. 4 years, 5 years, 6 years, whatever, there's a limit. So this, what I'm saying is that this examination would be relatable to this academic year. Even if it is held next year, it will be held for this academic year. Correct?
But my very little knowledge, I think they have semester-wise registrations.
PhD.
If my lord give me some time, I'll probably get an instruction.
You get it, because PhD is normally it may be semester-wise divided, but it's normally in years we calculate. 4 years, 5 years. IIT, I don't know. but it should be normally between 4 to 5 years. No, I don't know about it. That's why I'm saying, since I don't have knowledge, I won't say I'm knowing it. It is between 4 to 5 years. It may be divided in semesters, because normally PhD is done after it does a BSc course. IIT course is completed only then. Therefore, I don't think for a PhD there is an examination required. It's a news to me that he is saying that there is an examination.
In 5 minutes time, I'll come back.
No, it's okay. You come back, because what I understand is that in PhD you give a thesis, and this thesis you will be called in a what you call interaction to sustain the thesis. And if the thesis is found acceptable, this is what my old information is. 30 years I have got no information on this, but then when your this thesis goes to the academic, there's a division in the university who will evaluate this thesis, and after that your PhD is approved. No, I don't know. Let him come back. We will modify our orders accordingly. Since I am not aware, I won't venture.
Upgraded item 50 with production.
Okay. Mr. Tatha, your matter.
Item 50 upgraded with production list item 1.
Just a moment. Just a moment. Mr. Datta, before before you start, this is page 23. Don't show it to Mr. Ahmed. Keep it a secret.
20.
Page 23.
23. Don't let him look.
The read petition. Sorry, my lord, even in my page also it is like, I'm extremely sorry. I was thinking that why it's not there. I never thought your lordship's page is also like. I think the responsibility, my lord.
No, it's not a question of responsibility, but I think,
Serious matter.
but I think I'll adjourn it, take it day after tomorrow when the court reopens. You'll have to.
We require some time to.
No, you see, it is because of the urgency expressed in this order to take it up at disposal in the motion in this stage. That's why.
Urgency in it.
No, I don't know, but that is the order.
It's in the sense, my lord, The interim order is still today.
Okay.
Therefore, my
No,
lord,
but the language of the order is that disposal.
till the next returnable day, the status quo as regards the service of the petition as on today we maintain.
And then,
Returnable date is 10/11.
no, but something is said there, last word.
Last, then after filing the affidavits and endeavor shall be made to give a final consideration.
So that's why,
Therefore, my lord, the interim order may be extended since they want to file an affidavit. And then their matter will be get ready and your lordship may hear.
okay, and what is the subsequent development? This affidavit, this is something I did not read.
I will say that after passing of this order, my lord, the management is time and again, my lord, they are accompanying us to give the charge to a person, my lord, your lordship may kindly see at page 27 of the IA application.
27.
My lord. The lordship will find down below, two principal is signing. Because I am still holding the post of principal, they have brought another person who is sitting along with him.
No, but your substantive appointment is of a teacher,
Teacher. And then
and therefore regular principal will have to be given way, will have to give charge.
how it has been made, my lord, I will, my lord, enlighten your lordship.
No, but that may be subject to outcome, but you see, you are only allowed to hold charge. Your
Yes.
number one, your appointment, which I have gathered from the writ petition, is that your appointment itself was an ad hoc appointment. And you continue from time to time by extension of the service from time to time. And then you are allowed to hold the charge of in charge principal.
Exactly.
But if there is a regular principal,
Now I am holding the, still I am holding the post.
no, it's okay. But when a regular principal is appointed, you'll have to give way for him.
My lord, your lordship, hear this matter. I will take your lordship to all the papers, how I have been in the post till now.
No, you see, but the fact remains. From the writ petition, what I find is that you were just the in charge in principle.
Your lordship is very correct. And your lordship will find the person who has been brought, whether he is qualified or not, I will take your
No,
lordship.
qualification is something you'll have to challenge under writ of quo warranto.
He is, my lord, from the instrument department. Advertisement shows that he will have to have 10 years of experience in the school.
No, but you see, his appointment is not under challenge. And therefore, it is only a writ of quo warranto where I can examine whether he has got the, he has got the capacity to, or qualification to hold that post. In a-
Next date, your lordship can get.
Hmm.
Till such time, my lord, your lordship can protect us.
No, but principal, in charge principal is very difficult to protect you.
After hearing it, after hearing the matter, your lordship may take your own decision.
Please make your submissions. I'm ready.
Just for 2 or 3 days.
This will not help ultimately. There is no wrong with it. It's forcibly staying there.
But I will, my lord, explain how I have been there and how he has
No,
come.
you see, that's not in dispute that you are there. Nobody is disputing that. For the timing, your papers show that you are there. But the appointment, the substantive appointment, will only be of the teacher. In charge principal is only an in charge. If a regular principal, whether he is good, bad, or ugly,
So then, can I make a request to your lordship?
yes.
How he has been appointed, how interview is taken?
No, but that
Can your
has to be
lordship-
challenged, Mr. You see, by way of a IA, I have a reservation. Let me tell you that. And the reservation is that by way of an interlocutory application or by way of an affidavit, you can't amend the writ petition. And therefore, unless the writ petition contains the prayer, the purpose of examining the point will not arise, because the second principle is that interlocutory application, prayers made must be in aid of the principal relief. But if that prayer in the interlocutory application is beyond the scope of the prayer made in the writ petition, I have reservation in entertaining that.
Till the Tuesday or Wednesday, my lord, till Wednesday, you lordship give us time. In the meantime, my lord, we are coming up with the appropriate application.
Till Wednesday.
My lord,
Within the next, I mean, I probably, I won't be here.
Okay.
In meantime, we give a reply of this.
No, with the question of interim relief, that's the main point where we are oscillating in that.
Not maintain it, because the investigation is disposed of. They have not filed this document. You observe this on the court, whereby it is finally disposed. They've come in there.
No, I'm not following it. Since you see, what I've read is only my own reading. I don't know the, you'll have to introduce the facts to me.
Don't you this petition which was disposed of
That's the reason I'm telling you.
Yes.
on 16/23.
Huh?
It was finally disposed of on 16/23.
That's a different issue, my lord.
No,
Finally,
No, I'm not being able to catch. It's all Greek to me. Mr. Amit, please explain. I'm not being able to follow you.
Friend has filed an application, interim application, in a case which is already disposed of.
Is it?
And they have not filed that order, final order. They have not released it.
we are not on that.
No, just a moment. This interlocutory application 3325 is in writ petition 6018.
No. They
Earlier
filed
effect trigger.
the re-writ petition,
Effect trigger. Effect trigger. Now, again. that,
Just
my lord,
pass me over that writ petition file.
the new, but they filed the IA in the old police, which is disposed.
Oh, no, I'm not being, so just let me look at it. I won't. 6015.
His IA is 6015.
No. I think that's why you were and I were on a different page.
That a copy. But a copy.
No, the lawsuit account has still
No,
60.
just a moment. Because you have not corrected his copy. That is why that correct.
That was.
And I got it. That's why I'm showing it to Mr. Ahmed because now I follow it. No, I know. That's why you see I was not able to follow Mr. Ahmed's submission. That's why I got this repetition and saw it. But Mr. Datta, you'll have to give him a good copy.
Yes, sure.
Along with some coffee if he wants.
Yes.
Not as a respondent counsel, but as your friend in the bar.
Yes.
Huh.
We see it every day together.
So when do you want the matter to be taken up? 22nd November. Okay, but Mr. Datta, though I'm extending the order at your request, but I'm making an observation so that I remember the next date that I have reservations in extending the order.
Another observation that if he is in that board, because vice principal has already taken charge. On the
710.
My lord, orders for the facts, my lord. Possibly it cannot be accepted because still now I am holding the post and the documents show that.
It's okay.
Therefore,
It's okay. Whatever be, but we will give that protection till that. But I'll record my reservation.
Yes.
Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, counsel for the petitioner, as well as Mr. M. Z. Ahmed, learned senior counsel, assisted by Mr. A. Datta, counsel for the respondent numbers 2 to 7. CGC, who is there? Can record the name of Mr. Gogoi? No, don't be quiet. Just record the name of Mr. Gogoi. Tell him just Mr. K. Gogoi, learned CEC appearing for respondent number 1. Next para. At the outset, the Lawrence Senior Counsel for the petitioner gives due of the court to file a separate affidavit in support of the writ petition. As the affidavit which is on record does not show verification of the paragraphs on oath. Which
petition because what they filed for us is against WPC 3530.
No, it's okay. He'll give you the correct one. Full stop. Next para. The Lawrence Senior Counsel for the petitioner also submits that an interrogatory application being IS Civil 3325 of 2023 has been filed. So, however, well, the copy of the court has been corrected to by referring to WPC 6015 of 2023, the copy served on the Lawrence Counsel for the respondent numbers 227 has a reference to a different writ petition. So accordingly, he gives leave of the court to furnish to the learned instructing counsel for the said respondents corrected copy of the interrogatory application. Full stop. The learned senior counsel for the respondent number 227 has submitted that has paid for some time to file affidavit in opposition in the matter, and he opposes the extension of prayer for interim relief on the ground that the vice principal of the which institution?
BVFCL Higher Secondary School.
BVCL Higher Secondary School.
BVFCL.
BV.
Brahmaputra Valley Fertilizer.
Oh, sir, BVFC Higher Secondary School. Has been allowed to work as the headmaster of the said school, in charge headmaster of the said. He took charge of the headmaster of the said school on 7/10/2023. Full stop. The said submission is opposed by the learned senior counsel for the petitioner by saying that he has documents to show that he is still working as the in charge headmaster of the said school. Full stop. Next para. Having regard to the documents and pleadings on record in the writ petition, I primarily appeals to the court that the petitioner is projecting that she has been appointed as an ad hoc teacher cum demonstrator within bracket biology bracket of the BVCL FCL Higher Secondary School, and has rendered about 30 years of service by extension of her ad hoc service from time to time. And she was appointed as the in charge headmaster
Principal.
Sorry, principal of the said school. So principal of who? How the headmaster now? Principal of the said school. You are appointed when?
22. 7/12/2020.
22,
7/12, 7 December.
7/12/2022.
As in charge.
As in charge headmaster. In charge, I said in charge headmaster. As in charge headmaster, huh? As in charge principal. And that in the writ petition, the one of the pairs is for regularizing the service of the petitioner. First of all, the interpreter is to maintain status quo of her service in the post of principal in charge of BVFCL Higher Secondary School. So therefore, if a therefore it primarily appears that if a regular principal has been appointed, ad hoc in charge principal will have to give way to the selected candidate. Nonetheless, the issue is kept open to be decided on the after the pleadings are exchanged. Next para. The interim order of status quo with regard to service of the petitioner as ordered on 9/10/2020 is extended to the next date of listing. What is the document you have for that appointment of taking out of charge? What is that?
Charge has not been taken from us.
It's okay. I have already recorded. I have recorded it. That submission has been recorded. But if there's a document of any charge. But Mr. Ahmed, if what you call where is the impugn order in this replication, Mr. Datta?
In the read petition.
There's no impugn order here because you are asking for regularization.
Regulation, my lord, and while the order was passed, my lord, since we are holding the post of principal, my lord, on that basis, my lord, that interim order was passed.
They have not annexed the order of this. This is dated 16.
It's very difficult.
Interim orders, if any, passed in connection with the petition, shall also stand.
No, that was in a different petition, but this is a different petition now.
Claiming right on the basis of the old.
If you also look at page 27 of the I application,
The lordship will find that I am still holding the charge of principal. No. Principal BBS.
No.
If
Give,
it
give
will
give that
have a-
copy, give that copy, give that copy. Yeah, give that copy.
This I don't mean tell.
So Datta.
Yes.
Show you something. I think you better withdraw this writ petition.
So in this late petition,
No, I'll show you something. I'm fixing the documents in an order, particular order, so that you can read both things together. I think it would be appropriate if you withdraw this and file again.
about 610, we have
Just see that I'm showing you something in sequence. You see, in the top is the judgment of 610, correct?
Yes.
Now look at the date of filing, it is 9/10. It may amount to suppression of facts.
So this, on when we filed it, this order was not out.
No, maybe, but you see, on 9 you are filing it. That's why I'm showing you that the
Yes.
seal of the court is 9/10.
Right.
But if we have been directed to withdraw it and file a fresh writ petition for regularization.
Right.
If
We have done that.
if the statement is not here about the dismissal of the earlier writ petition, it may lead to other consequences.
Just 1 minute.
Uh-huh. You think over, we will come back in 5 minutes. Let me
Right.
do some other work. Let my mind be clear. Correct.
This possibly some confusion is there.
You just take it. I'll take it up after 5 minutes. In the meantime, I refresh myself with some other work.
Right.
And then come back to it.
I've talked to the student. They said that nowadays, after he's the first year, he is a student. They have to simply the examination after completion of 6 months. It is called course examination, course work examination. That will be start from 19.
I have got some clarification, my lord, but the last part I'm not being able to clarify. They are finding it out. So firstly, my lord, the appellate authority will sit in coming 5-6 weeks. Appellate authority is the board of governors. The representation was made to director. Within 5-6 weeks, that is what they told me. Secondly, my lord, that with regard to this semester pattern and whether he can do it, like I have already communicated to them. But the HOS is.
No, it's okay. Then if it's a semester examination, then we allow him also to sit in the examination. The results can be kept in hold. Same thing. Otherwise, you will find it difficult to hold exams later on.
Very difficult.
After 6 weeks, it will be difficult on your part to hold an examination. I know that because examination is something I have to deal with it for some reason. It's very difficult, Mr. Dey. To hold an examination for one person will be very, very difficult. let them take the examination. Yes, ma'am. Second also, PhD examination, the examination result will be kept in hold. Same order. Tinta case with the same order.
Same.
Order.
Much.
Production.
Mr. This is something I am aware of. Holding of re-examination is something I am aware of. It is difficult. If it is difficult, if you find it otherwise, just Mr. KL, wait for some time, let him get a clarification. If they can hold an examination. No. You see, IIT and all, we are giving them special consideration because of the fact that in this IITs, IIMs, in this medical, there are time limits given also by the Supreme Court of India to hold what you call certain examinations, admissions in a phased manner, and that is why so much of concern. Because I don't want this order to be violative of any judgment of the Supreme Court of India, and therefore holding of examination. You see, IITs there are all over the country. Now to hold an examination out of turn, I don't know whether your regulations will permit it or not permit it. I am absolutely not aware. So that is why I am giving you some more time. Let him examine. Let it be in the what you call in a seal cover. That will be more better. Okay. Seal cover. Objections are same order and passing. You did object, so therefore no problem with that.
I'll just take 1 minute.
Huh.
It's just, my lord, I'm very sorry.
No, it's okay.
The honorable court should not be confused in that manner.
Huh.
What happened, my lord? On this 6/10/2023, this order was not uploaded. When we started, please let me finish it. You will have your turn. All of three can say all together. My lord, this sort of confusion is very bad. It's the worst thing. Now it was uploaded when we are arguing the case. My junior brought that. Now that's the reason exact wordings your lordship will not find them. Now why this sort of confusion should be made before the court?
No,
We
you
have a
see.
responsibility. We are responsible.
No. You see. No, not that, Mr. Datta.
You have your turn.
Talking about the confusion being right.
Confusion you are making.
No,
That's the
please.
reason I'm saying.
No, please don't have acrimony in the court. I'm good enough.
It's not very fair.
No, not that. But you see,
Because
if
the
I
order was not
no, the order may have been uploaded sometime, but you see, the order has been dictated in the open court.
My lord, what was the exact order is not there.
No,
That's
that
the reason, my
no,
lord.
that may not be there. But is it stated that the earlier writ petition was dismissed and then?
No, my lord, we have withdrawn that.
No,
Withdrawn that and we filed
no. Where is that statement in the writ petition?
statement because it did not make, because this order was not in our hand because it was not uploaded when we filed it.
Writ petition.
And if it is required by filing an affidavit, I can say that. So it is-
No, non-uploading can be understood because this is even in my code it happens a lot of time. The reason is that by the time I dictate, just for example, today, the order of yours which I'll be dictating, I'll not be able to upload it today.
Exactly.
Correct, because of the fact that there'll be a transcription typing out. Then they will, while going out, I'll tell them that this examination, which is starting from today, that is to be done in priority. So they'll type out that order in priority. Any bail matter for which Mr. H.R. Chaudhary is sitting, maybe that will get a precedence.
Those are the things practical.
So for that, no, but
What
the
happens
question is that, no, but have you stated that this was withdrawn? That statement is there.
My lord, that
Order may not have been uploaded.
Para 15 minutes. Page 15, para 15. The read petition. 6015. Lordship may come the middle part. This honorable court again on 6/10/2023. After hearing the matter was pleased to dispose of the read petition setting aside the NIT dated 29/5/2023. issued with management and holding that recruitment of teachers as skilled laborers by third-party contractors is outright illegal, and further granting us the liberty to file a press petition. Now, how we have suppressed the things?
No, once you state that, that's good enough.
Therefore, either the confusion should not be made unnecessary.
No, it's not confusion. It's something which I will think if I'm a lawyer for one party, I'll think that the order passed today has been uploaded today.
But I was thinking what mistake I have committed. But after getting to see all these things, I could realize that these are things what happened. Because of the urgency, without getting the copy, we had to file it. Because they are contaminating to us too.
You see, representing this order, in fact, in one of the meetings, I had an occasion to have with one of the senior officers. This skill development, this is skill development, right?
They are the teachers.
No, this is a skill development. No. It's a regular school.
They were given in the hand of a contractor, they issued an NIT, to engage these teachers as a commodity. The appeals court has,
No, this is not that. You see, even there are schools which are handed over to private organizations to run it because they don't have that managerial capacity. Such schools are, I'm aware, at least at 2 places, including the Bangaigaon refinery. Those are being handled by private organizations who, because of their, because you see, this large companies, they don't have managerial skills for running the schools. Therefore, they gave it to others. Even the NRL hospital.
Software hospital, I don't have to say anything. So the teachers.
No, I'm just saying because you see the NRL, they don't have the expertise to run a hospital, so therefore their NRL hospital has been given to, it's been outsourced.
Teachers, the apex court is said.
No, I'm not on merit, but once you have said that, it's okay. But Mr. Ahmed, you see, normally we find that when somebody is asked to give to take charge, you'll be asking someone to give them charge.
Handover.
Yes. So where is that direction? Others, you have to show from the rules that your rules permit that if ex parte, if somebody who's asked to give charge does not give a charge, then you take an ex parte charge. Like the government of Assam has a standing circular. It says that once you are directed to give charge, if you don't give, same is in Arunachal also. If you don't hand over charge, then unilateral charge will be taken up after a particular period of time. Oh, okay. Oh, okay. Then you just say that status quo passed earlier stands extended to the next listing. This is interim order, last part. Okay.
Lord, I'm obliged to the Lordship for showing me page 23. Page 23 of the requisition, lesson learned.
No, no. No.
I'll have to see the next.
No. It is just because of my irregular background. Since I come from the right side.
Nowadays, invariably, these things are happening. So I'll have to give a
Since I come from the right side of this institution, that is civil court, the first habit is to look at the affidavits.
It's a nice habit.
No. Bad grooming up.
It is necessary. We are being misled. It's not that we have.
All right, my lord, I accept. If you want to say that, I accept.
Maybe let us have
At
an,
least your office has understood.
you'll have to give an arm wrestling competition and then.
Well, the mark is pretty severe to us. I hold him at much high esteem, so this much I can say. But when it's a matter of fight, my lord, we will have to stay up to the last.
There's a lawyer politician give a speech that if you can't, if you have a good case, we argue very, what you call, very lucidly. When we have a bad case, we shout. And when we have a worse case, then we also bang the table.
My lord, possibly in Guwahati High Court, the lawyers are very decent, they never do that.
No, I'm not saying that. I'm just saying words of a famous politician turned lawyer, lawyer turned politician. This is his statement. He's a man of reckoning.
Politicians like R.P. Sharma, they use.
No, I don't know. I'm not saying names. Names I forget. Very bad memory. But what I remember is that he gave a very good statement about the lawyers arguing on a brief. Good case, soft spoken.
That's it.
Bad case, shouting. Worst case, then you bang the table.
The lawyer has the experience. Obliged.
4 weeks? Sorry, no, they give a date of 20. 20.
25%.
23rd. Due pari? Due pari? 23rd. Okay.
Obliged.
Yes, bail matter. This is bail matter, NDPS matter.
61 with 62.
I am for 61.
Yes.
But in this case, when we file, actually, in order to mention that it was rejected. When it was listed, then we bought your washing product, we came to know that it was rejected earlier. So this is there in the mention my original was filed.
It's okay.
And order dated. Order dated 9/10. 9/10.
No, it's okay. No issue with that.
So.
Okay.
The order is also yet placed.
Okay.
Now, your lordship order, my lord, today is this person is in custody for 550 days.
550.
50 days. 550.
550.
550. Arrested on
What is the stage of trial right now?
trial number 6 to our information out of 10 PW3 examined. Subsequently, I do not know, I don't know what to say. Now there is no chance of immediate murder. Moreover, so far the present petitioner is concerned.
As per the charge sheet, how many witnesses are there?
10. Not 10 numbers of witnesses.
10 witnesses.
10.
How many examined?
3 examined to our information. Subsequently, why not 12, 9.
Three numbers of witnesses are already being examined. And number 4 is safe examination is pending. PW4 is not completed.
No, you see, you see, if you can't produce witnesses for if 550 days, people are inside, you'll become entitled to the bail.
Permanent resident local person.
No, this doesn't carry a meaning because after in cases of 22C, commercial quantity, people do vanish. Not one. We have seen not one.
That you also mentioned, earlier.
Not one. That is the great difficulty. People just vanish.
But here, 5 months is matter because recovery is not from his possession. 5 months, subject to what. Anyway, matter 550 days, I think matter. That's your worship.
Because even very recently, the Supreme Court has come up heavily against the courts not granting bail when the trial, very recent judgment.
Sir, my last July, I think, some July or September, August.
No, in fact, it will be October, this October.
But July, to I have said that kind of both to be fundamental right as well as the other side, both to be reconciled. And here actually only 262 grams minor, 12 grams more than commercial fund. That could contain.
You have any recent judgment or July you're referring to?
So last minor, the July, August judgment was there. The rights also is right on the 21 or so to be looked into, provide both are to be reconciled.
Fix it on Tuesday.
Yes, I
And fix it on Tuesday. Let me check up. No, not on that, because the earlier rejection order also I have referred to the particular that's thing until. That is, since it is a what do you call 3-judge bench, that is.
Also, you have mentioned some other case.
But it says about the under trials also.
Until also it is stated, in regards of 37 will not come. Provided that is also there.
We take it up on Tuesday. Next reopening day. Be prepared with the case laws.
Two minors, so that because they normally your lawsuit is regular bench. Otherwise, we can wait the whole day.
No, you just tell me. Just tell the court master your convenience. We'll ask the APP to be there on that time. In the morning, please ask your Mr. Sullivan can.
After motion matters,
After motion matters. After motion and normally no motion and admission. But he may tell the court master will adjust accordingly. APP will be informed. List on, we'll give Tuesday the list on so for consideration of this bail application.
14.
Tuesday is 14th. Working day. Because once I'm not taking a regular bail matter, I'm not updated with the case laws.
But yes, but nobody your lawsuit is having your lawsuit.
No. You see, this will be acquired knowledge. But normally when I am taking a bench, I'm otherwise updated with that subject matter. So had I been taken a the bail regularly, I would have been updated. But from education to bail, I just lost track of the current judgment. That's the reason. Because these days my bench is not is an undecided bench. I'm in division bench. I'm in single bench, and then change of bench.
Next time, division bench, then again single bench.
No, that's why I'm saying that when I'm not taking a bench, I'm not updated.
I think by this evening everything will be settled. This evening everything will be settled. For last 2-3 weeks, 1 week,
no, we don't know. Because every day is an uncertainty, but the fact remains that when I'm not taking a bench, I'm not updated.
What is uncertainty?
I just can't be updated.
Daily list. Item 11 for admission.
Oh yes, there's tender matter. Okay. This R. Gogoi. D. Gogoi. This D. Gogoi was there.
I have been back to the division.
इसे कितना
আর গুগল পেন ড্রাইভ এটা দিয়েছিল
ও আচ্ছা
আমার
ये
Pen drive.
हाँ ये given that pen drive
Yes.
what did you want to show from that?
Very simple issue. The tender of the petitioner was rejected at the technical stage due to non-submission of the affidavit as given in the format in the tender document.
Oh acha I remember, yes, there's some language difference.
Language difference.
Huh.
The format is also basically he has made his own format, and I had also produced the original records. Lordship had produced the CS, and in the tender document matter, the page 50 of the petition, Lordship will find there is a format. Only that much, my God.
Yes, 50 is that verification format, yes.
So
Huh.
our contention was that it was not provided in that manner as provided, so it was rejected. And another that was, and that even in that affidavit what was filed by the petitioner, the name of the mohol with the concession area was different.
No, I did not catch it, please repeat again, show it to me from the documents.
In Lordship will find at page 50, one has to, while bidding my lord, one has to give the name of the quarry or mohol for which is bidding my lord.
Okay,
So here, my lord, there was a slight difference in the name also.
okay, where is that?
It's in the pen drive.
Oh acha, okay.
So that's simple issue, whether it matches this format or not.
Name of the mahal. Mr. Mahanta, you have anything to say?
Yes, yes, that too,
Huh.
my lord, and the second question regarding my lord, eligibility that affidavit, my lord. In affidavit, my lord, and now that's not what there is a main difference. Recovery query that you lost, can you see page 61? Page 61, my lord.
Yes.
So your lordship, can you see the last page? The last line, madam. With the tender process concerning recovery query. So it is instead of recovery query, madam, the recovery sand and gravelment. It should be. That is, madam, rectified. And probably the another affidavit we have filed the page 93. Para 2. Para 2, my lord.
Just a moment.
That will not, my lord. And that is also, my lord, in the affidavit, my lord, they have not stated also.
Page number?
Page number 61.
No, 61 I have seen.
Page number 93, my lord.
93.
Para 2. Yet I have
Just a moment. Sand and gravel MCA.
Mining contact area.
Okay.
That is my, so that is, I have submitted my documents in respect of, so that is very clearly in the second affidavit, I have clearly mentioned. So my lord, another point, my lord, your lordship kindly see, they have stated that my lord, it is not in format. I have submitted my affidavit, but they say it is not in their format. So in that case, my lord, your lordship kindly see, it's a public interest involved, my lord. I offered 4 crores. They have given to my lord person who is only 1 crore, my lord. So 3 crore difference. And my lord, that defect, assuming that defect, my lord, what they can, my lord, do, my lord, that is immediate. They can easily, my lord, page 42, your lordship kindly see. Page 42. Page 42, my lord. Minor deviation. The state government.
Just a moment. You are outside on in technical evaluation.
Technical evaluation. That means also they have not informed to me, my lord. There is a provision, there is a principal judgment that has to be, my lord, informed, my lord. And in that part of in Dhemaji area, my lord, all my lord, quarries are, my lord, below. Someone offered 6 crore, giving to 1 crore. Someone giving 4 crore, giving to 1 crore. Always in the, my lord, lowest than I. Even another case is pending also. In that case, there is a stay order, my lord. Always, my lord, they are looking for the lowest bidder. When offering highest bidder, my lord, in the silly ground, my lord, they have bidder.
Your bid is how much?
My bid is, my lord, 4 crore 45 lakhs 511. And his respond number 5.
4 crore?
4 crore 45 lakhs 511. And BW respondent number 5. Settle with the value respondent, 1 crore 10 lakhs. Sorry, 1 crore 13 lakhs. So 1 crore 10 lakhs. 1 crore 10 lakhs. Yes. 1 crore. So my lord, 10 page 42, what I wanted to point it out. It has minor deviation as a logic.
Yes, I have read it.
That is that they have not applied it, that is that they have not gone for it, my lord. And another point, my lord, they have, my lord, taken in the affidavit that it is technical evaluation. So we do not know what is the final evaluation. That is not correct. Your lordship, why it is not correct? Page, my lord, 32. Page 32, my lord.
Just a moment.
Page 32. First round of E-auction. subclause A, subclause 2, an initial price offered which shall be equal to the or greater than the reserve price. So, what is the price I have, my lord, quoted? That has to be, my lord, equal or greater than the reserve price, my lord. Can your lordship can page 32? Page, sorry, 33, my lord, clause C. Clause C only those
Just a moment, just a moment. Yes.
Only those bidder who's found to be eligible in accordance with the terms and condition of eligibility specified.
You are reading where? Which page?
Page 33C. Page
33C. Okay.
Only those bidder those bidder who are found to be eligible in accordance with the terms and condition of eligibility specified above in clause 5 with valid supporting document as stated above, whose initial price offered is equal to or greater than the reserve price referred to the technically qualified bidder shall be considered for second round of evaluation. So, my lord, in technical bid itself, my lord, they know the price, my lord. So otherwise, my technical bid will not be accepted. So that is not that, my lord. They do not know the technical bid of the financial bid of the others, my lord. So in their affidavit, they have taken that plea. That's why I am submitting that. So my submission before your lordship, my lord, the defect which was raised by the authority, my lord, that's a curable defect, and that, my lord, they can exercise the power that as mentioned in the tender evolution that report, my lord. So, my lord, without giving any chance to rectify it, or, my lord, that without applying that clause, my lord. So their government is losing 3 crores of rupees, my lord. That's my submission.
Yes.
This is short reply. Every pleading has to be substantiated by it. So that averment, that 4 crores, my lord, I improve my lord senior to, my lord, indicate wherein his tender form, my lord, where it is written 4 crores. So the question of granting, my lord, at a stage of technical bid, lordship is very well aware that technically, and regarding the other charge that is being pressed, that they were not informed. My lord, this is lordship very well aware. Lordship had once settled one tender process. Lordship had called for the employed people once. Lordship remembers. In that, my lord, these are all tender online tenders. A person he submits.
No, first of all, come to page 10. First line.
Yes, but this has to be managed, my lord.
They have not been denied, my lord.
No, not done that. You just said to him, you are imploring him to show something, and I have showed you.
Still, I'm imploring that pleading has to be substantiated by a document out here, my lord. Annexed to it here. That I may be wrong, my lord. Send correction. And apart from that, my lord, that pressing charge, that serious charge that he was not informed, my lord, these are all online bids. Every person has his own digital signature. And when a bid is, my lord, my lord's offered or rejected or accepted, my lord, a person is on his mobile and registered mobile number, my lord, the bidder is informed through it, my lord. And regarding that issue, that it is, my lord, it can be curable and that is a minor deviation. A person has to approach, my lord. a person has to approach the PCCF or the competent authority that see, my bid has been rejected. So there is a provision out there, in the bid document. So you kindly go through it and condone this defect, which is a minor in nature as claimed by him. That's all, my lord. And I also rely upon, my lord, is Bharat Cooking Code, para 28 to 34. And whatever I'm submitting, my lord, it's also stand taken categorically in the affidavit, my lord, in the concluding paragraph of paragraph 7 and 8. I address the issue. Sure, thank you. Very- But you know, still then for my convenience, my lord, I'm just guessing that hard copy of Bharat Cooking Code. May I submit?
Yeah, just now. Paragraph 32.
And also, my lord, 20, actually from 20 to 34. all the-
28 to 34.
Yes.
You know the background of Jagdish Mandal case?
My lord, that I am not very well aware. This month, my lord, that was a celebrated month.
No, no, judgment is celebrated, but why it is celebrated, you know that?
Only my lord, proposition did not was, my lord, that judicial, decision making.
No, if I remember it correctly, that was a case where the where the auction was conducted in the Supreme Court. Read that.
That is but in almost all cases, my lord.
No, no, but read that. You have got Jagdish Mandal.
Yes,
My lord, Jagdish Mandal.
he has got money. From him, I came to learn this.
Jagdish Mandal was that an offer was made and the Supreme Court said that how much can be, how much it could be, a bid can be improved. And the bid improvement was astronomical. That is why.
2007, 14 SSC 5 months.
1714.
2007, 14 SSC 5 months. And that is being reflected in all the cases, my lord, that central coal field, national high speed, my lord. That was, I get these two judgment, my lord, latest judgment 2016 and 2022. This one is still relying.
Oh, no, I'm wrong. It was not this case. It was not Jagdish Mandal. It was Ram and Shyam. In Ram and Shyam, the audit, the auction happened in the courtroom. And there was astronomical rise in the bid price. The offer which was earlier 5.5 lakh. In course of course proceeding, it went to 25 lakh. That happened inside the court. So therefore, that's just wrong in giving the reference to Tata Sil, sorry, this Jagdish Mandal.
Another aspect, the approach, the delayed approach in this honorable court. The LOI was issued in 30 September 2021, and the petitioner approaches this court in the month of May 2022. And
LOI issued on
30/9/2021. Petitioner approaches, if I am correct from the affidavit page, its date is not clear, specific, but it's the month of May 2022.
13 May 22.
And my lords, in the plain, my lords,
What is the tenure of this
7 years.
7 years?
And as regards the delay, my lord, there is no amendment as to what. Sorry, my lord, is 5 years. 5 years. 5 years. Oh, 5 years. In the plain, my lords, in the body, there is no whisper as to what has caused the delay and what has, let's say, the petitioner approaching this honorable court or another forum. Anything is granted.
Okay.
I'm
My first submission will be on the point of delay. Because by the time the petitioner approaches this honorable court, my right has already been crystallized, Your Lordship. Your Lordship will kindly note the dates, Your Lordship. 21/6/2021 is the e-tender notice was issued, Your Lordship. On 3/9/2021, technical bid was evaluated, Your Lordship. On 3/9/2021.
NIT was issued on 21/6/21. Yes, bid evaluation.
Technical bid evaluation was on 3/9/2021. Now on 9/9/2021, Your Lordship, that will be petitioner submitted an RTI, Your Lordship.
On
9/9/2021. Initially, no reply was given, Your Lordship. On 30/9/2021, Your Lordship, provisional LOI was issued. In the meanwhile, Your Lordship, on 12/11, Your Lordship, 2021, the petitioner received the copies, some of the copies, Your Lordship, some of the answers to his queries made under Right to Information Act. And the comparative statement, Your Lordship, was provided to him. Now, Your Lordship, on 1/12/2021, the work order was issued, Your Lordship.
On which date?
1/12/2021. And 5 months thereafter, Your Lordship, around May, Your Lordship, 2022, the petition was filed. So, Your Lordship, there is, Your Lordship, delay on the part of the petitioner, Your Lordship. And as a result of which, my right has been crystallized, Your Lordship, for this particular contract, Your Lordship. And therefore, Your Lordship, on that ground alone, Your Lordship, my humble submission, Your Lordship, would be that this writ petition is liable to be dismissed, Your Lordship. And in fact, Your Lordship, apart from the fact that, Your Lordship, the writ petition, Your Lordship, in the entire writ petition, Your Lordship, there is no explanation why this delay has been caused, Your Lordship. Nowhere it is mentioned, Your Lordship. And in fact, Your Lordship, he could have gone to the PCCF, Your Lordship, ventilating his grievance. He could have filed an appeal, Your Lordship. Statutory appeal under rules, AMMC rule, Your Lordship, rule 68. That he did not do, Your Lordship. And after
What's the
waiting,
provision for appeal?
rule 68, Your Lordship.
Rule 68 of what rules?
After minor mineral concession rules 2013, Your Lordship.
I'm handing over.
Some minor minerals. Oh, I think we have it. No, it's okay. We have it. You have given me it last time. You've given us last time. I have preserved it. 69.
60. There's a CD there. This is the second thing.
Great.
Now, Your Lordship, in the meanwhile, Your Lordship, after work order was issued, Your Lordship, I made substantial investment, Your Lordship. I have brought an affidavit, Your Lordship, showing my investment there, Your Lordship. I have to made investment for, Your Lordship, approach road. I have to collect my materials, land, etc. Everything I have done, Your Lordship. In the meanwhile, Your Lordship, this had he come in time, had she been vigilant, Your Lordship, she could have come before this honorable court, even if she does not go to move the appellate authority, Your Lordship. And then these investment, Your Lordship, from even assuming he has a case on merit, Your Lordship, I could have been, Your Lordship, safe, Your Lordship. Now it is that because of this delayed challenge, Your Lordship, made by the petitioner, Your Lordship, if Your Lordship intervene at this period, Your Lordship, I will suffer, Your Lordship.
But how does this issue of both of you have argued about the period of limitation? What is the limitation for 226?
There is no limitation. As such, there is no limitation. But, Your Lordship, I will rely on two judgments, Your Lordship. One by Honorable Court, our High Court, Your Lordship, and one on. This is Your Lordship, you kindly go through, Your Lordship. Judgment, Your Lordship. The facts are, Your Lordship, narrated in paragraph 3, Your Lordship. Is it tender, Your Lordship? For construction, Your Lordship.
Just give him the photographs from Mr. Oh.
Here your lordship, para 3, subpara 2, Roman 2, the date of NIT was 23 to 2017, your lordship. Next page, your lordship will get your lordship. Date of opening of technical bid was 17/3/2017. Para 6, your lordship. Although the date of time of opening of the technical bid was fixed at 2:30 p.m. 17/3/2017, yet according to the writ petitioner, the same was not done, so on stipulated at any time for reasons not known to him. When the respondent number 3 had failed to inform fate of its technical bid, despite repeated inquiries made in that regard by the representative of petitioner number 1 firm, a representation was submitted on 1/4/2017. And on 1/4/2017, he was informed that bid submitted by it has been rejected on technical ground.
And it approached the court when?
Then, your lordship, on 2/6/2017, he approached the court. That is, your lordship will get it at your lordship next page, page 5, your lordship, below the designations is there. Roman 10. On 2/6/2017, he approached the court. Now, this honorable court, your lordship. Para 16, your lordship, of this chapter.
Yes.
Since impeachment of the writ petition has been sought on the ground of delay and laches, let me first deal with the question of maintainability of the writ petition.
Yes, please continue.
Lost.
Hmm.
WBC 33402007. To their pleadings, the respondents have taken a categorical plea that writ petitioners have failed to take proper legal action in the matter at a stage when the technical bid was rejected, and therefore are guilty of delay and laches. It is to be noted here that the date fixed for opening of the technical bid was 17/3/2017, and the financial bid opening date was fixed on 24/3/2017. It is the case of the writ petitioners that although the technical bid were opened on 17/10/2017, those were not evaluated on the day, nor were the bidders intimated about the reason for not doing so. The writ petitioners have made an attempt to explain the delay in approaching the court by taking the plea that due to pendency of the departmental inquiry ordered by the minister, there was some delay in filing of the writ petition. Record reveals that petitioner has submitted a representation before the departmental minister on 9/5/2017. That is after a lapse of more than a month from the date of fixed opening of the financial bids. But even in the said representation, there is no prayer to hold the process of awarding the contract to the other bidders. There is no convincing explanation in writ petition as to why the petitioner number 1 had to wait till 9/5/2017 for seeking an inquiry in the matter relating to rejection of the technical bid, when the date fixed for opening of financial bid is 24/5/2017. Even the representation dated 1/4/2017 was filed about 2 weeks.
You can skip and come to paragraph 20.
20 and 21.
In paragraph 20, last 5 lines, you will see the cause, after the date when the cause of action has arisen, by that time more than 75% of the work has been executed.
By the respondent for under a.
So definitely after 75, this is a maintenance contract.
Lots.
So if 75% contract is executed, then no point. But here this is a sand mahal.
Your Lordship may kindly come to next para 21.
Yes.
In competitive bidding of the nature involving bids submitted in two parts, the eligibility of the bidders are evaluated both on technical criteria as well as on the strength of financial offers. The question for considering the financial bid would arise only when the bids are found to be technically valid. Therefore, the evaluation of process proceeds on a rapidly changing backdrop where each phase of the tender process constituted distinct as signifying the creation or extinguishment of the rights of the bidders. It would therefore be difficult to accept the hardcore businessmen having sufficient experience and expertise in such bidding processes would remain silent in the matter even after expiry of the date of opening of the financial bid, merely because the authorities has failed to inform about the outcome of the evaluation of the technical bid. An experienced contractor such as the writ petitioner number 1 is expected to be well conversant with the implication of each stage of the tender evaluation process and would normally be extremely alert in protecting its rights and interests at every stage of the tender process by seeking prompt and appropriate legal remedy and as and when the occasion arises. Then, Your Lordship, para 23. It is fairly well settled that the law limitation would not have a strict application in a writ proceeding and a delay is not to be applied as a obdurate rule to deny relief if otherwise allowable. But law is equally settled that if the delay in approaching the court gives rise to a parallel right being created in favor of a third party, then relief can be denied on the ground of delay. What would constitute delay and laches in a given case would depend on the facts and circumstances of each case, and no inflexible rule of interpretation can be laid down in that regard. However, in a matter involving commercial interest of the parties, the court would have to be tread with caution not to entertain a stale claim, particularly when the same would lead to trampling upon the rights of adversely created under a concluded contract. In the case of Dharampal Satyapalli, then there is a reference to these cases here, right? It's a general proposition laid down by this honorable court, Your Lordship. Although, Your Lordship, there is a reference to that, Your Lordship has pointed out, Your Lordship, but it's a general proposition laid down by this honorable court, relying on certain judgments of the honorable apex court, Your Lordship. And then, Your Lordship, para 26, Your Lordship, equally important, Your Lordship. In the case in hand, the petitioner's grievance relates to rejection of its technical bid. In the facts and circumstances of the case, if the plea raised by the petitioners are to be accepted, the ultimate relief that could be granted under the law and equity was for this court to direct the authorities to reconsider the technical bid submitted by the petitioner number 1 and open its financial bid. But such a relief would be permissible only at a stage when the tender process was yet to be concluded and when no right has crystallized in favor of the successful bidder. Entertaining such a prayer after conclusion of the tender process would amount to setting the clock back, which should be impermissible in the eye of law. This is the general proposition laid by this court, Your Lordship, by this judgment, Your Lordship. And that way, Your Lordship, the right that has been crystallized in my favor, Your Lordship, and I will also show, Your Lordship, that the 4 crore, Your Lordship, the quoted rate of 4 crore, Your Lordship, in a live auction, Your Lordship, which will be taken place under the, Your Lordship, Antron, Your Lordship. This has no meaning, Your Lordship. Ultimately, that will the auction, the rate quoted at the auction will be the ultimately decide the fate of the tenderers, Your Lordship. Then Your Lordship will kindly go through this judgment, Your Lordship, of the apex court, Your Lordship, on delay and laches, Your Lordship. Yes. Your Lordship is taking up my other judgment, Your Lordship. This is related to service law, but Your Lordship, the issue of delay and laches, Your Lordship, in approaching the court, Your Lordship, has been decided, Your Lordship. Your Lordship will kindly come to para 21, Your Lordship, of the judgment, Your Lordship. 2022 QSC 25. Para 20 and 21 and 22 euros. May I read your-
Yes.
21. The word laches is derived from the French language meaning remissness and slackness. It thus involves unreasonable delay or negligence in pursuing a claim involving an equitable relief while causing prejudice to the other party. It is neglect on the part of the party to do an act which law requires while asserting a right and therefore must stand in the way of the party getting relief or remedy. 22. Two essential factors is to be seen are the length of the delay and the nature of acts done during the interval. As stated, it will also involve acquiescence on the part of the party approaching the court apart from the change in position in the interregnum. Therefore, it would be unjustifiable for a court of equity to confer a remedy on a party who knocks its door when his acts would indicate a waiver of such right. By his conduct, he has put the other party in a particular position and therefore it would be unreasonable to facilitate a challenge before the court. Thus, a man responsible for his conduct on equity is not expected to be allowed to avail a remedy. Your Lordship. This is your Lordship, para 22 of this judgment, Your Lordship. And then Your Lordship, para 28, Your Lordship, Article 226 of the Constitution of India, Your Lordship.
Yes.
Then Your Lordship, reference to judgments, Your Lordship. In para 28.2, Your Lordship will find
Para
28.2,
2.
referring to Eastern Coalfields Limited.
Yes.
As to delay and laches on the part of the writ petitioner, there is a substance in the argument of learned counsel for the appellant company. It is well settled that under Article 226 of the Constitution, the power of High Court to issue an appropriate writ order or direction is discretionary. One of the grounds to refuse the relief by writ court is that the petitioner is guilty of delay and laches. It is imperative where the petitioner invokes extraordinary remedy under Article 226 of the Constitution that he should come to the court at the earliest reasonable possible opportunity. Inordinate delay in making the motion for a writ is indeed an adequate ground for refusing to exercise discretion in favor of the applicant. Now, Your Lordship, this delay, Your Lordship, why this delay of 5 months has taken place? That has not been explained, Your Lordship. Even if had there been some explanation to it, Your Lordship, then also, Your Lordship, this court would definitely, the court of equity would go into that, Your Lordship. But here is a case, Your Lordship, that has not at all been explained, Your Lordship. And 5 months in a contract like this is a vital, Your Lordship. The first 5 months, Your Lordship. Huge investment made by the third party. Party in favor, in whose favor Your Lordship right has in the meantime accrued. And it is not, Your Lordship, small investment, Your Lordship. In my affidavit, I have annexed, Your Lordship, the investment I have made in the meanwhile, Your Lordship. That aspect, Your Lordship, is required to be looked into by this honorable court, Your Lordship. And thirdly, Your Lordship, the argument, Your Lordship, of my learned senior friend, Your
You have definitely seen a mining area.
Lordship, I have seen, Your Lordship.
You have seen. You're convinced that the what they call the heavy expenditure which you have referred to is justifiable.
No, Your Lordship, not that, Your Lordship.
No, not in this case.
Lordship.
Not in this case. But if you have seen a mining area in
Lord.
one place, to have a conviction to say that There'll be huge investment in a mining area in a second place. Something which,
Machinery is your lordship, basically.
no, machinery is okay. You said some time ago that you have made approach road and all those things.
Your lordship is required to be made, your lordship, because from the place where mining is to be done, your lordship, to be your lordship. Because your lordship, mining is normally your lordship by the side of either hills or your lordship, the rivers, your lordship. Therefore, your lordship, and it is not in the same place, your lordship. Every 5 year lordship, the places changes, your lordship. Yes, ultimately deposition of mineral. That is the point. Where it is deposition takes place, your lordship will have to move there. Your lordship. Okay. And finally, your lordship, on the point of your lordship, this rate of 4 lakhs. Your lordship. Ultimately, it is a 4 crores. Your lordship. It is your lordship for initial entry, your lordship. For technical qualification, one is required to quote a rate, your lordship. That rate, your lordship, should be the purchase price, your lordship, that has been reserve price that has been mentioned in the more than 1 rupees of the reserve price mentioned in the. So I quoted that, your lordship. Ultimately, had there been a it is in the auction, your lordship. I participated, your lordship, in a live auction, your lordship. My rate, your lordship, found to be the highest. What fault is there, your lordship? And your lordship, so far as this defect is concerned, your lordship will kindly see this defect. Page 61, your lordship. This affidavit is a very important piece, your lordship. This is not that, your lordship, because your lordship, here, your lordship, he has to, on oath, he says, your lordship, that these are the documents in respect of the particular mohol. I have submitted these documents, your lordship. If that particular mohol's name is wrong, your lordship,
Agreement, payments of the mohol.
then your lordship, these documents, your lordship, tomorrow, if your lordship, for some default on his part, if had it been a case, your lordship, that he is awarded the contract and there is default, your lordship, how could have, your lordship, the authorities proceed against him, your lordship? He could have pointed out that these are not the documents in respect of this I have, it is your fault. And ultimately, your lordship, whether it will be an essential or not, a particular terms of the tender is essential or not, it is for the tendering authority to decide, your lordship. That's what, your lordship, the CCL 2016 8 SCC, your lordship, has said. Page 622. Paragraph 48, your lordship. Whether a particular terms of the tender is essential or not, that is for the authorities to decide. If authority decides that yes, it is essential, then it is essential. And if they decides to waive it, your lordship, one cannot demand as of right, your lordship, that yes, this is a not essential terms of the tender, therefore it should be relaxed, your lordship. Your lordship will kindly just one paragraph of 2016 8 SCC 622, your lordship, paragraph 48, your lordship. Small paragraph, your lordship.
Which?
2016 8 SCC central phone page. Upon 2016 8 SCC 622.
2016 8 SCC.
Page 622.
622.
I am relying on paragraph 48.
Yes, what is that?
I read, your lordship.
I think other matters I will not have time to take up. Because I have to, I will not be able to take up matters.
Production of last item.
Which item? Just a moment. There is a production case which has come up. Elementary education. Oh, okay.
Teachers have already joined a base period. The teachers have already joined a base period.
Mr. Kanto, I'll take up this matter. It's a motion matter. I will come back to this. Just take up the motion matter.
Here, Lord, is the provision for file an appeal. And
No, just a moment, unless, just give me 2 minutes. Mr. Borgme, what is the violation of that memorandum?
My lord, violation of this memorandum, my lord, this school, my lord, basic school, my lord, this school has, my lord, less than 40 students, my lord. And our school has, my lord, better infrastructure and, my lord, students is also, my lord, 61 present, my. But, my lord, they have filed, my lord, one appeal before the commissioner, page 25, my. Not considered, my lord, in the meantime, my lord.
not, it should have been filed before the director. Moreover, first of all, the petition has no.
No, just let me understand. Which page you are showing me?
Page 22, losses, cost 12. That is the violated that he has alleged. Losses. Page 22.
Page 22, clause 12.
Yes, 12 number, cost 12.
If two or more UP schools are located within so and so, then these ME schools may be merged. So what is your school?
My lord, my school is Jolilia ME School.
ME school.
Yes.
And it has been merged with which school?
Sodarband ME School.
That is also a ME school, it having a better structure, losses, yes.
No, let me complete, I'll come back to you. Okay, so you have 63 students.
Yes.
It is merged with a school which has 40 students.
Less than, my lord, 41.
Yes, so
But custody, my lord, page 24, my lord. Page 24, my lord, clause 19, my lord. It is provided that a director concerned will issue necessary orders for amalgamation for any disputes arising out of order. The aggrieved, my lord, institution, public also, my lord, may appeal before the government in the secondary or elementary education department as the case may be.
But yes, highly happy before the deputy commissioner.
Or deputy commissioner may be provided to govern the appeal before the public.
the deputy commissioner has a lot of work.
Yes,
If the deputy commissioner becomes a postman because of the order of this court, I'll not be very happy.
and moreover, teachers, they don't have any, they have already joined the base school. That's my telephonic instruction that I have received. And students will also move losses. only he being he was an ex-president of the SNC, School Management Committee. So his interest that he wants to be a president of that, he wants to continue.
No, no, but
That's the only his interest.
yeah, my lord, my father, my lord, donated.
The old Hindi movie, Kissa Kursi Ka.
Yes, exactly that.
You're not seen that movie.
Page 14, my lord, this is the, my lord, land deed, my lord. With the condition that, my lord, if school is, my lord, in future shifted elsewhere, my lord, this land will go to, my lord, the donor. This is the father, the petitioner of this land.
But Mr. Bobby, you see, government is paying salary. They said that you go there, amalgamate, and you get a salary from that school. What will be your objection? You see, once you have donated the land, after donation, they become the somebody becomes the owner. You can't give a condition. The condition attached to a donation will not be sustainable.
But my lord, they have, my lord, made the base school, my lord, which is, my lord, inferior to the, my lord, present school, my lord, Kisana school.
But my instruction is otherwise.
Can we adjudicate on that? Which school has a good condition, which has a bad condition? What is good for you may not be, maybe very bad for me. Because these are subjective. Unless there is a parameter which says that you see, for example, because of this good, bad, and ugly, now for the purposes of the court, the Supreme Court has, by judicial order, devised that the court buildings should be of a particular size. It has laid down a parameter. It has laid down the infrastructure basis on which the new complexes should come up. And there is also a direction that the old complexes should be converted into a better complex because of that. Then there are directions of the Supreme Court for creation of child-friendly courts. There are directions to construct vulnerable disposition centers and so on and so forth. There are many directions which have come up. Now, in the absence of any state policy that a school building has to be of this size or this structure or that or this. Now, how will I say?
Something is there, my lord, page 22, my lord.
Page 22.
My lord, under clause 15, my lord.
22, 16. Yes.
15, under 15, my lord.
Huh.
Subclause, my lord, A, my lord. Small a.
Having good infrastructure facility with an amicable academic atmosphere. Yesterday we were dealing with a school, not yesterday, day before yesterday. School which is having size of 16 into 15, correct? It was 16 into 15, 150 students of 5 classes, class 1 to 5. And the petitioner who was in support of that school says that it is a good condition, good school. So that's why I said, what can be good for one may not be good for me, because I raised this question: how can 5 classes be held in a bamboo pillar structure, thatched house, which has 16 into 15? No, sorry, it is 40 into 15. That was size was 40 into 15, and 150 students out of 5 classes, class 1 to 5. Now I made this statement at the bar, this with my low voice, because I can't speak without speaker. If I speak without speaker, you will not be able to hear it. So if I use a speaker, then also people have difficulty in understanding me. And with that low voice, in a 40 into 15 room, if I teach A, class 5 students who will be in the class of maths will be able to hear me. And therefore, one class is Assamese, one class is Hindi, one class is arithmetic, one class is some other class, science. All students will, you can understand. It's a, what you call, knowledge of all sphere. In one go, people will get. So therefore, what was good for that was not palatable to me. I should have noticed to the government to tell us whether it is acceptable for the government. If the government says yes, this is acceptable to us, that will be good. So how do I evaluate? My question is that how do I evaluate? I don't have the technical expertise. Because we all have our we all have our own notions of what is the school atmosphere.
There is some provision, my lord, under clause 19, page 24 in the.
19.
19, they have to file an application for director of it, not before the district commission.
Page 24, my lord.
There's a provision is there to file an appeal if they have
Remedy is
given.
there, my lord.
Hmm?
Remedy is there, my lord. After evaluation, even, my lord. There is a. But before.
Where is the order of amalgamation?
Constitution order, my lord, page, my lord, 29, my lord, nectar 6,
29.
page 29, my lord, nectar 6. My school serial number, my lord, 5,
5.
5.
Because it is on 13/10/2023, Lord.
And it was given effect, my lord, recently, my lord, page 32.
32 losses में खाली payment losses, the DO has.
Just on, Mr. Sesi, I'll come back to you.
That notification, my lord, I referred, my lord, on the basis of that notification dated 3/8/2021, my lord, this amalgamation order was passed, my lord, and to implement, my lord, this amalgamation order, another order has been passed, my lord, by the concerned block inventory education officer. This is at page 30, my lord, and etc. My lord, it is not school, my lord, maybe made page 2.
This is a policy decision. The court can't sit in appeal and decide which school will be the best school, which will not be the best school. Interference in a policy decision is can't be envisaged. No, Mr. Paul, we have closed this petition. You will be permitted to file your appeal before the appropriate authority. Was there something? You see what you have said here in paragraph 5. You see the petitioner was required to be the school of the petitioner was required to be amalgamated with the status of school. Simultaneously, land of the donated by the father of the petitioner in the name of the school in question ought to have been given to the possession of the petitioner. So if that is the submission, that means school is not a reason you are here.
My lord, I submit my secretary, my lord, if my lord.
No, so you see, if the land is given to the, then you have no objection, because that would mean very simply.
There is my lord, some condition in the gift deed, my lord. Therefore, my lord, I have made this, but I am not.
No, then you file a civil suit, get it
not
back,
insisting on
get
that.
it cancelled, get it annulled. because after what do you call, you'll be we will not go into those aspects. The question of hiba, what would be good, what would be bad, what can be done, what can be the conditions which can be imposed. Those are something the civil court can decide. We'll just close it and say that you file an appeal before the appropriate.
The school becomes obviously the property, it became a property of the state law.
No, he says conditions, but I'm not going into it. Then we'll have to, because I'll have to enter, that's not an issue here. I have to enter into the principles of hiba and then decide. Not going into it. Heard Mr. A.M. Barbihal and counsel for the petitioner, as well as Mr. S.M.T. Chisti Lanet, standing counsel for the school education department. Next para. The amalgamation of Jalia, Jallia, ME school, Chandipur, Chandipur, part 2, Roman 2, Hailakandi with Sadarbond, Sadarbond, ME school at Chandrapur, part 2. Wide order dated 13/10/2023 and other directions by order dated 30/10/2023 and consequential directions by order dated 30/10/2023. For first order will be 13/10/20 passed by the Director of Elementary Education Assam, and consequential orders dated 30/10/2023 passed by the BEO Hailakandi have been assailed in this writ petition filed under Article 226 of the Constitution of India. First off, at the outset, the learned standing counsel for the school education department has referred to clause 19 of the office memorandum dated 3/8/2021, which gives power to the government to order merger of schools. And it is submitted there under clause 19 thereof. The provision for appeal by institution of the public before the government in the secondary education department has been provided for. Next para. In this regard, the learned counsel for the petitioner has submitted that against the proposed action of the respondents, a representation dated 12/7/2023 was already submitted by the petitioner and other villages before the Deputy Commissioner, Hailakandi. And accordingly submitted that the said authority ought to have communicated the, ought to have forwarded the said representation to the competent authority. Next para. In view of the provisions contained contained in the OM dated 3/8/2021, providing for appeal under clause 19 thereof. The court is inclined to close this petition with liberty to the petitioner to file an appeal before the
From the secretary.
before the secretary to the government of Assam.
No, secondary school education will comprise of both secondary elementary. Secondary school education will
Secretary School Education Assam, which is stated, with the learned standing counsel for the education department, school education department submits is the common authority for elementary schools as well as secondary schools.
Yeah.
Full stop. In the event such an appeal is filed, comma, in view of the liberty granted by this court, comma, the same will not be rejected on the ground that it is delayed. Full stop. The petitioners, comma, if so advised, shall also provide their email address so to enable the authorities to communicate with him. Full stop. With the forced observation, this writ petition stands closed.
Yeah.
Uh,
There is no such time reject word rejection lawsuit. That should not be otherwise it will be taken otherwise. They will not. They lawsuit. That lawsuit said that.
Achha, so just say it like this.
Otherwise there is no time limitation lawsuit.
Okay, just say like this. Just don't write that, huh? It will not be rejected on ground that only said appeal shall be entertained and decided by the authorities with a speaking order.
Yes.
Okay. Preferably within a period of 1 month from the date of receipt of certified copy of the order.
Along with a copy of the repeats because it is disposed in a motion stage. He will also submit a repeats and copy of it.
No, writ petition is not required. He submits an appeal. When he's submitting an appeal, he will submit whatever is required. Why this writ petition? He may give additional documents also. This time he gave representation of 20 people. Now he will give representation of 100 people. Correct. Elections are coming and they will be decided in that manner. Closed. Yes.
My item is 63. I have that by order at mine. Maybe take on 15.
What do you want in that? Notice in contempt matter.
Yeah.
It's an order of which date?
Order will that is that's 22/9/2023.
22/9/2023. Okay, contempt matter. Mr. A. Rashid, counsel for the petitioner. Willful and deliberate valid non-compliance of order is so his arrest. Notice steps within 2 days. Pendency of this contempt petition shall not be a bar for the respondent authorities to comply with the order of the court.
Item number 63.
Last item.
Give a list, give a date of appearance, contempt matter. After 4 weeks, give a date for appearance. Yes.
Take 2 minutes.
Ah.
Para 48 of this 2016 HSC. Para 18, para 48 of 2016 HSC.
Cool, okay. CCL.
Therefore, whether term of NIT is essential or not, is a decision taken by the employer which should be respected. Even if the term is essential, the employer.
This is para 22.
Para 48.
48. Okay.
Therefore, whether a term of NIT is essential or not is a decision taken by the employer which should be respected. Even if term is essential, the employer has the inherent authority to deviate from it, provided the deviation is made applicable for all bidders and potential bidders as held in Ravana Dayam Safety. However, if the term is held by the employer to be ancillary or subsidiary, even that decision should be respected. Lawfulness of that decision cannot be questioned on a very limited ground as mentioned in the various decisions discussed above. But the soundness of the decision cannot be questioned. Otherwise, the court will be taking over the function of the tender issuing authority, which it cannot. Ultimately, it is for the tendering authority to decide whether it is essential or not. And if tendering authority in the present case has decided that this is not, this is an essential condition that will have to be followed, then matter ends there in my humble submission, Your Lordship. Therefore, Your Lordship, the 226 code, Your Lordship will provide.
And what is your answer to that submission of Mr. Mahanto that your quotation was 1 crore something and his quotation was
Your Lordship, my submission is this. Let's say Your Lordship first round of auction and then second round of action. In the first round of action is the 1:4 amount, Your Lordship, just above the
reserve price, your lordship. Reserve price, I have quoted just above the reserve price, and this is for clearing the technical bid, your lordship, entering in the second round, your lordship. And I have quoted that, your lordship, and on that basis, your lordship, second round of live auction have taken place, your lordship. In live auction, your lordship, ultimately will decide who would be the highest bidder, your lordship. That will, he has not taken part in the second round of litigation. Even if your lordship decides to intervene in this matter, your lordship will have to direct them to consider it from afresh from the point of your lordship clearance of the technical bid, your lordship. Your lordship will have to move the clock back, your lordship. That's the point, your lordship. That's why, your lordship, I have relied on that. Ultimately, this is the situation.
No, let us take a situation which Mr. Goi will answer us. You see, in this sand mahal or gravel mahal auction, let us say in the along with the tender, somebody quotes 4 crore rupees. Correct. 4 crore will lead to this case. So let us take 2 crore rupees. Correct. Now, in the tender process, the bidding, which takes place in the second part, as a bidder, can A say that now I am starting from rupees 100?
No, that the highest bid will be the price, highest price quoted in the first round, your lordship, will be the true price.
No, but what is his stand, the government stand?
My lord, as he has pointed out, my lord, the first round, my lord, class 1, whatever you quote, once one clears the technical issue, my technical bid, my lord, it will start from the base price. Auction will start from the base price. That 100 rupees was the base price, 100 plus 1. One may quote, one may say that to clear the technical stage, he may say astronomic figure. We are asking for 100, he may come with 1 lakhs. But my lord, once the first round is over, second stage of financial auction will start from the base price. It will start from the 100 plus 1, 100 plus 2. It will go on that side, my lord. And it is, my lord, there's a live auction, and they are given a key, they are to take part. And the lordship allows me, my lord, two citations, my lord, on the delay, my lord. There's some limitation. It's my lord. And lordship has that tablet. I have a soft copy. It's my lord. 2005, 3 SCC, 91. Para 31.
Just a moment.
My lord.
Yes, give the citation again. 2000?
2005, 3 SCC, 91, page number. Paragraph is 31, 33, and 34. Herein, my lords, name is, my lords.
No, that's why we've got it. RM Trust.
Yes, my lord.
Yes, go ahead.
My lord, herein, my lord, Ramana Diaram Shetty is quoted. Page para 35. In Ramana Diaram Shetty, my lord, I don't know too much about it, my lord, but this paragraph which is quoted therein, there was also a challenge to a work order of a restaurant. My lord, that challenge was more than 5 months. And the Honorable Court on that ground also refused to interfere, that one has to be vigilant. And third party has already invested. And that delay itself was fatal. And my lord, the court refused to interfere, my lords. In paragraph 34, my lords, of that paragraph 34, my lords, there is no doubt that delay is a very important factor. While exercising extraordinary jurisdiction under 226 of the Constitution, we cannot disturb the third party interest created on account of delay. Even otherwise, also why should the court come to the rescue of a person who is not vigilant of his rights, my lord? That one, my lord, and another just last concluding, 1986, my lord. 86, 4 SCC, 566. Paragraph is 24. Now, if I may read, it starts with, now it is well settled that the power of the High Court to issue an appropriate read under 226 of the Constitution is discretionary, and the High Court in the exercise of its discretion does not ordinarily assist a tardy and the indolent or the acquisition and the lethargic. If there is inordinate delay on the part of the petition filing a writ petition, and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in exercise of its jurisdiction. The evolution of this rule of laches or delay is premised upon a number of factors. The High Court doesn't ordinarily permit a belated resort to an extraordinary remedy under the jurisdiction because it is likely to cause confusion and public inconvenience and bring in its train new injustices. The right of the third parties may intervene, and if the jurisdiction is exercised on a writ petition after unreasonable delay, it may have effect on inflicting not only hardship and inconvenience, but also injustice on third parties. When the jurisdiction of the High Court is invoked, unexplained delay coupled with the creation of third-party rights in the meanwhile is an important factor which always weighs with the High Court in deciding whether or not to exercise such jurisdiction. Well, the paragraph is very big. That is the paragraph I conclude my
all the my lords, citation given before your lordship, unexplained delay. Your lordship kindly see. In my writ petition, from para number 5 to para number 10, your lordship kindly see. I have clearly mentioned in a clear term why it is delayed. It was not in my learned friend, my lord, the government official and the government respondent, my lord, not denied it, my lord. From para number 5 to 10, my lord. In fact, I made a statement that, my lord, therefore, he keep the file to that so that in his possession, my lord, so that he cannot oppose the Honorable High Court. I made a statement that in my lord, para number 6, that is also not denied. So now they say that I have not explained, my lord. Everything I have explained, my lord, very properly, and that is not denied by the government official, my lord. Your lordship kindly, so that's why the submission which was made before your lordship, so that the citation, these are all unexplained delay, my lord. But in 226, there is no bar, my lord, but there is no limitation in the post, my lord. But I have made my statement very clearly in para 5 to para 10. And regarding, my lord, one, my lord, submission I have made, that is 2022, my lord, their judgment, 2022 6 SCC 401. The National High Speed and Corporation Limited, in that case, my lord, that everything, right from Michigan rubber, that Central Coalfield.
What is the citation?
2022 6 SCC 401. In that case, my lord, when this honorable court, when High Court can, or 226 can be interfered in this type of matter, my lord, that para 29 it is, my lord, para 29. Here in this case, my lord, all are, my lord, discussed. 22 6 SCC 401. 22 6 SCC 401. Yet here in this case, even that Judicial will also discussed. So, my that is my submission. But I have very clearly explained, and my lord, another thing, my lord, they say that it is well, court informed. But in their affidavit, they have stated those who are qualified in technically, my lord, responsive, those who are informed in their mobile. That is in their affidavit, they have stated. So, my lord, they have not, my lord, informed my rejection order, my lord. And that is also there is a judgment of the Honorable Apex Court, my lord, that I will place, my lord. So that is also not denied, my lord. That is 1990 3 SCC 280. In para 10, 1990 3 SCC 280. Regarding non-informing the rejection of the technical. I'll give the judgment.
Pass it on.
lordship can give it. Regarding my lord, non-informing the reject. It is not that my lord unexplained delay, delay of 4 months has been clearly been explained. And my lord, that para not been controversial, that been denied by the official respondent.
That is,
Which paragraph?
Para 5 to 10, of here my lord, para 10, his judgment. Para 10.
that is kind of denied. In paragraph number 8 of my concluding paragraph number 8 of the affidavit in opposition, it is clearly stated, my lord. In case a bid is directly accepted, the bidder is informed of the fate of the bids through the mobile numbers.
To the who are qualified. Your lordship kindly see his their affidavit.
My lord will read my page number 5.
Page number 5, which page?
Affidavit in opposition, my lord, paragraph number 8, which is starts at page number 4 and conclude at page 5. Lordship will kindly start with the concluding paragraph, which starts with further it is pertinent. Further, it is pertinent to mention here that when a bidder takes part in a bid process, the same is done and facilitated through an online portal. A bidder can download bid papers, collect necessary information, etc. for the portal online. The bids are also submitted to such online platforms, and the bidders are informed of the submission of the bids to registered mobile numbers. In case a bid is rejected or accepted, the bidder is informed of the fate of the bids to the registered mobile number.
There are 8 first part, my lord.
At the cost of delivery, it is further stated that bidder can also access the online platform through their own digital signature and get the necessary information as regards rejection or acceptance of the bid or the stage of the bid process.
In fact, my lord, they open the my lord, technical bid, my lord, without any notice, my lord. That your lordship kindly see that is deferred. That as per the tender notice, my lord, they have to open it, my lord. When they have to open it, my lord, on that which was fixed, my lord, that is not been, my lord, open, and they have opened in 3/9, my lord, without notice to me, my lord. Without notice to me, they have opened it, my lord. So that is I made in my reply, my lord, para 7, I have stated, my lord. As per my lord, as per their earlier notification, they have to, my lord, open it on, my lord, by 24/7/2021. But they have opened it, my lord, 3/9/2021. When they have informed that they are going to open, my lord. Your lordship kindly see page 24, my lord, 23, my lord. Page 20 of my petition, my lord. Start of the technical bid evaluation, 24/7/2021 at 10 AM onward. But they have opened it on 3/9 as they stated in their petition, my lord.
Start of technical bid is what date?
24/7/2021.
Okay.
But they opened it on, my lord, from their, I came to know, my lord, that it is open on 3/9/2021 in para 7 of my affidavit in reply. I have stated that without informing.
Para 20?
Para 7 of my affidavit in reply. I have stated, my lord. So that is without notice to me.
Okay.
Short reply.
No reply.
Just concluding, my
No,
lord.
no, no. Absolutely not.
It is particularly responsibility of the
No.
bidder to ask
Also, my lord,
authorities.
No, that's
what
okay.
happened to my
But
Hold the original
But
documents with me.
4:15 extended to 5:13, 5:15 is too much. No, I am not hearing it. I am not hearing it.
As regards technical bid, my lord.
No, I am not hearing it again.
And then get put your
The- I have got a good, what do you call, habit. I can keep my eyes open and go to sleep. So therefore, when I say I don't hear, I don't hear. That's one. And second thing, if I don't open my file, I'll not know what is inside. So I can shut down my mind very conveniently. You've seen that. Once I open the file, I remember. But if the file is open, I won't remember anything.
My lord will retrieve that page, right?
This time I'll remember. The argument of Mr. T.J. Martha, Senior Counsel, assisted by Mr. J. Sharma, Counsel for the petitioner. Mr. D. Gogoi, and Standing Counsel for the Forest Department. Along with this R. Gogoi, Counsel, Standing Counsel.
No, I'm already there. He's Bhattakur for the respondent number 7. Right?
Okay.
I have already asked.
And Mr. S. Bhattakur, and Counsel for the private respondent. Have been heard. Just correct the language. This one have been heard. The Learned Standing Counsel for the Forest Department has produced a pen drive containing
Affidavits, soft copy of the affidavit submitted by both parties.
soft copy of affidavit submitted in the tender by both parties.
Only
So, by the petitioner. Okay. By the petitioner. Okay. I've been concluded. Judgment is out.
CAV during December.
No, this will be CV because I won't have time.
CAV.
2 days I'll not be working for Diwali. So CV.